that decision, it appears at 011-117. The SCA there, it makes it clear that it assessed only the first three requirements. It says there is no need to go to the fourth requirement, that is the Gijima principle. Why? Because the SIU had not made out a case for review in that case. That's what the SCA says. Paragraph 81, it says, in light of the inordinate delay which has not been sufficiently explained and which has been found to be unreasonable, the egregious conduct of the department, the fact that the review application has no merit, and the prejudice to be suffered by other contracting parties, and so then it says the delay should not be overlooked. Paragraph 82, we do not even get to the Gijima principle of whether the decisions to award the tenders of the service level agreement should nonetheless be set aside, as no clear unlawfulness in the awarding of the tender and contracts were shown on the facts. So that case is unhelpful to Manyan friends because it is distinguishable. In this case, we show that there is illegality, and we'll deal with it in more detail when we now deal with the merits. So those are the four requirements that the court has got to look at, and we say if those are applied, the SIU comfortably meets the test. There can be no doubt about that.
Mr. Motebo, can I just ask you a question in relation to the point you're dealing with? Yes, your emphasis is on the SIU as an institutional agent who brings this application, stepping effectively into the shoes of the SABC.
Yes, ma'am.
But unlike in many similar cases, the SIU has not come alone here. Yes. The SIU has come with the SABC, who sits in an entirely different position. So a lot of the factors that you rely on apply to the SIU, but not to the SABC, because the SABC is an institution which is a going concern. The fact that there was an interim board that only came in 2017 is neither here nor there. The SABC is an ongoing concern, and the cause of action arose in 2016 when it did. So what should I make of that distinguishing factor from the cases that you've relied on?
Yes, my lady, what happens in matters of this nature ordinarily, once the SIU is appointed, the state organ involved basically takes a step back, because the SIU now leads the investigation in terms of the proclamation, and it is then that the SIU will bring an application. So even though the board was appointed in March 2017, even though that is the case, but once the SIU is appointed, the SABC could not be held to be bringing an application in total ignorance of the proclamation, in total ignorance of the appointment of the SIU. It had to defer to the SIU because it is the SIU appointed to investigate. So that will be our answer, my lady. But
so are you saying the proclamation gave rise to factors that resulted in a new cause of action, given the SIU's involvement? I'm just trying to understand your reasoning in line of, the applicable principles. I understand factually it came late, but why should I excuse the fact that the SAP has always been there? It conducted its own investigation, and there's no explanation as to what it did out of that investigation, what it found, what it did. There's absolutely no explanation.
Yes, no, my lady, and I cannot obviously give evidence from the bar, but the point I make is that in this sort of matters, and it may not appear in the affidavits, but in this sort of matters, what the SABC would have done is then refer this matter to the SIU once it has prima facie thought there are irregularities. Refers to the SIU, The SIU then is appointed by the president. And I say that is an intervening event. At that stage, the SABC could not, on its own, could have just proceeded and ignored the appointment of the SIU. That is the argument that we advance. But we say even if we're not correct on that score, and even if this court finds that there are insufficient grounds to overlook the delay, we say this is a case where the Gijima principle must apply. That's the point that we make, because if we don't, SABC is going to suffer prejudice. The delay in relation to the repayment is another issue, as I've indicated, my lady. But the delay in relation to the decision itself, we submit that the Gijima principle must apply, and the court must overlook that. Otherwise, the SABC is going to be prejudiced. It must still continue paying over 8 million rands, which it doesn't have. So that is our argument in relation to that.
Thank you.
Yes. Then, my lady, there are other points in limines. I'm not going to waste too much time on them, but the one that I should address is the issue of prescription. Now, we do not disown what our predecessors say in the main heads, again, that one must look at prescription from July 2016. But we say that should be an alternative argument. The main argument that we want to advance is that, and in the supplementary heads, we refer to the contract props matter. It deals with estoppel, yes, but we say the principle is applicable here. Now, we deal with that in paragraphs 15 to 19 of those heads. The reference is page 017-12. And we say, as the SCA found in that case, contract props, that prescription cannot be relied upon to perpetuate an illegal state of affairs. We say similarly, one cannot raise that private law remedy to perpetuate a private law remedy of prescription to perpetuate an illegality. More so, because we're dealing here with section 172 of the Constitution. Once the court declares the conduct of a state organ unlawful, in terms of section 72(1)(a), it has a very wide discretion under 1B, and it cannot be held to be curtailed or limited by a private law defense like prescription. So we say it's inappropriate to refer to prescription like private law remedy. It's untenable, and because invariably, in matters where the SIU is appointed, invariably, well, let me not say invariably, but there are many cases in which the decision sought to be impugned happened more than 3 years earlier. This will mean that the SIU will never be able to recover. Even though there's declaration of invalidity under section 172, it will mean that it will not be able to recover, and the court will not be able, under just an equitable remedy, to demand repayments if this private law remedy is to be entertained. So our argument is that, in line with the principle in contract props, it's inappropriate to refer to prescription in this case. So therefore, that point in limine should be dismissed. Now, my lady, I've dealt with the issue that this is a legality review. There's an issue that was raised that the SIU has no locus standi. I'll have to wait for the respondents to develop this point, because from what we see, I do not understand on what basis do they say the SIU has got no locus standi. But for what it is worth, we deal with it in the supplementary heads. I'll just give references at paragraphs 20.
The tribunal has ruled on that issue numerously.
Yes.
So I would expect the respondents raising it to persuade me that I should depart.
Indeed.
The tribunal has dealt with that issue.
Yes, indeed, my lady. Then there's another issue raised about improper commissioning of the affidavits, and the point, as we understand it, it attacks the affidavits in the investigation, not the affidavits that constitute the pleadings before court. And they say the deponent to the funding affidavit, supplementary affidavit, and the replying affidavit commissioned the affidavits during the investigation, the affidavits of the SIU during the investigation. But we say there's nothing untoward with that. The regulations dealing with, and we deal with that at paragraphs 23.
That issue too has been previously decided by the tribunal. I think it's in the Gauteng Department of Education matter, Mbofane. Fikile Mbofane versus the Gauteng Department, many others. SIU versus Fikile Mbofane. In that case is prevalently known as the school's decontamination case. That issue has been decided too there. So,
thank you, my lady. I'm not going to then waste any more time. Then lastly, there was the issue of non-joinder of the board members, but we say there's absolutely no need. What we have joined is the parties, the role players in the decision, in the impugned decision. And there's the operations committee, and there's the individuals like Mr. Aguma, and also Ms. Rapela, as will show, they have signed the business case. The signatures appear there, so they were intimately involved. So these are the role players that we had to join, and that's what we did. There was absolutely no need to join any other party. One and that argument it relates to the board members. The argument being that we ought to have joined other board members, but this decision was not taken by the board. So why is there a need? The fact that one of the board members might have been in some show when this was announced on television does not necessarily mean that the board members took a decision. What we are taking here is the decision that was taken, and we show why we say it is this specific decision. None of them were involved. So that point too, my lady, it holds no water. Now, if I may then deal with the merits and why we say the decision is unlawful. In paragraph 55 and 56 of the funding affidavit, this is at page 001-33. The allegation is that when this decision was taken, there was no policy governing this. And that seems to be common cause. But of course, we'll hear from our opponents if I'm correct. But that seems to be common cause, that there was no policy. So I've given reference in the funding affidavit, page 55 and 66. But this we also refer to the supplementary funding affidavit. I may just refer your ladyship there. We rely on paragraph 8 in the supplementary affidavit. We rely on paragraph this supplementary affidavit to the funding affidavit. So it's not the reply, because one of the criticism is that the SIU makes its case, or the applicants make their case only in the reply. It is not true. The funding affidavit might be terse in certain respects, but it was augmented by the supplementary affidavit once the record was filed. And the supplementary affidavit specifically refers to further affidavits that were found during the investigation. It also refers to the specific policies that we rely on. And the references are given from the record. So in paragraph 8, we emphasize the point. The applicant emphasizes the point that there was never, well, firstly, there was no policy. Secondly, it is common cause that this decision was not referred to the board. It's not the board that decided this. The committee that took the decision, and this is common cause, and I want to firstly deal with the 5 September decision before I come to the July decision. The 5 September decision, that was taken by the Operations Committee. And we must perhaps start with the terms of reference of that committee. Your Ladyship will find the references at page 005-8835 to 005-844. I need to look at my hard copies. I'm not a fan of online references, my lady. I'm sorry. My lady, the terms of reference of the Operations Committee.
Mr. Motepe, please give me the page number, case lines page number again. Did you say 844?
005?
Yes.
835. That's where it commences.
835.
Yes, those are the terms of references. Now, there are various clauses, of course, that we say we rely on, and some of them we also deal with in our heads of arguments, the main heads of arguments. But the important one for now, it is clause 2.3.
On page?
2.3, it appears at page 839. Page 839. But in our heads, we deal with it in paragraph 47 at page 007-39.
Please give me the paragraph in your heads again.
47.1. These are the main heads.
Okay.
Yes. And this is just to lay the basis. It reads, the committee must review and recommend to EXCO a 3-year business plan containing details of operational plans.
Sorry, paragraph number again. Are you reading from the terms of reference?
47.1. I'm reading from
the heads, okay.
Yes, from the heads. So in the heads, it is quoted.
Okay. You may proceed.
Yes, basically it says the Operations Committee must have this 3-year business plan containing operational plans, marketing, financial plans, and policies and all that. So the point we simply want to make is that your leadership will see that the payment of the legends, for example, is not part of all this 3-year business plan that would have been approved.
Yes.
It's not. Now, in paragraph 4.7.2 of the heads, we then quote clause 4.2.5.
Yes.
Of the terms of reference, and this is important. It says, so the committee must ensure that all transactions recommended to EXCO for approval are in line with the corporate goals that will fulfill the Broadcasting Act objectives to maximize revenue and increase shareholder value, that they comply with the values of the broadcasting service and had been budgeted for. That's important. Now we know, as we sit here, there was never a budget at all for this expenditure. It was not budgeted for, but what is important is that before you make any sort of addition as member of the Operations Committee, you've got to satisfy yourself, as told as were told by clause 4.2.5. Clause 4.2.7, still in the same paragraph. It says, consider the impact of all transactions presented to it. There's misspelling there. Presented to it on the financial viability of the corporation, including but not limited to whether the transaction has been provided for in the budget. Again, paragraph 47.3, and this is a very important one. The committee has got no independent decision-making powers. It does not have. So if, for example, in the business case, 3-year business place, there are certain operations that may demand that there's approval of certain monies, the committee may do so, but up to 50 million. We'll get to that. It may do so, but it must be operational. If it's not operational, it is not in the policies, it will have no independent decision-making powers. It must, in fact, as I'll show in terms of clause 7.1 of the delegation of authorities, rather refer that to EXCO or the board if it is unsure of itself. Now, in this case, as I've indicated, there were no policy. The matter was not budgeted for. It's not a matter that falls within operations, and therefore is not even in the business plans. And yet, and even though it was aware that it has got no independent decision-making powers, the operations committee proceeded to make the impugned decision. And we say that is wrong in law. Should not have done that. Now, I will refer to perhaps I must refer to the decision itself, but I was also still dealing with, because I want to avoid there's going to be an attack that as I argue, the points that we argue are not found in the funding affidavit, but we say if one reads the supplementary affidavit carefully, the case is also made out quite clearly. And we refer in this instance to paragraphs 8, 9, and 10 of the supplementary affidavit. Of course, proceeding, but as I argue other points, I'll make other references. So the attack that the case that we make only appears in the funding affidavit can therefore not be correct. Now, coming back to the decision of 5 September, and now I want to refer your ladyship to annexures to the funding affidavit. The first one is SIU 3. It's at page 001-48. Is your ladyship with me?
Did you quote it in your head? In your heads? I'm avoiding going up and down because I'm
no, it's we did not quote it in the heads, and I'm not going to
give me the case. Do you want me to go there, or are you happy to just argue?
No, I'm happy to make references.
Okay.
It's page 001-48.
001-48.
48.
Thank you.
Yes. Now, this is an extract from the minutes of the operations committee. They were approved on 29 September, but it relates to the minutes of 5 September. So there must not be a confusion. Although signed 29 September, but it refers to it was approval of the minutes of 5 September. It says so itself. It's a certified extract of that minute.
Yes.
Now, in that minute, your ladyship will see, and I need not quote in detail, but in paragraph 2.2, under that, the first unnumbered paragraph, the first line, it says Mr. Motsoeneng stated that the SABC intended to pay identified local veteran musicians by the end of the week, and that additional fund for backing vocalists would be raised at a later stage. So this is what Mr. Motsoeneng said on 5 September, that the SABC intended paying by the end of the week. We know though, so this is what he said on the 5th of September, but we know that by the 5th of September, there has never been any decision taken by the SABC, and we're talking about a decision authorized by policies or delegation of authority framework. There had never been. So he was presenting this to the operations committee so that they may decide on this. Then on the second paragraph, there was a concern raised about the number of these legends, because your leadership would recall initially the decision was to pay 180 legends. So there was a number, there was a point raised about this number, and as I'll show in the business case subsequently, it was extended. This number was increased. But what I want to refer to is the decision of the operations committee, which is recorded under resolution. Paragraph 1, and I'm going to just read that. It says a once-off payment to the local veteran musicians and choirs identified from the initial list B and is hereby approved. So the operations committee does not say we recommend this to the EXCO or we recommend this to the board, because this is not a matter that falls within operations of the SABC. It's a new issue altogether. So let us get the approval of either EXCO. It doesn't say that. Even though clause 8 of its terms of reference says it does not have independent decision-making powers, it specifically says it approves. And that's what happened. It approved that. When it approved this, there was no business case. And I want to make the point, but let me refer the leadership to Annexure SIU 4. This is a business case dated 29 September 2016. And it must not be confused with the business case that ought to have been approved before 5 September, because as I've indicated, there was an initial decision to make payment to 180 music legends, and later on it was increased to 215. Now I want to show your leadership that this is what this business case was about. And I'm going to give reference. These are the delegation authority framework at page 005-2242. 005-2242. Now, clause 9.4. I'm going to read that into the record. The business unit to which the budget has been allocated and which is seeking the approval for the initiation of a project must submit a business plan containing at least the information detailed in 9.6 below. Business plan must be submitted in respect of the following categories of expenditure. 1, content commissioning and acquisitions, including current affairs programming, sports rights acquisitions, capital expenditure, trade exchanges, sponsorship, deals, and travel. Now, my lady, this was never submitted. By 5 September, there was no business case submitted before the decision was approved by the operations committee. Let us analyze what is this business case then that appears at SIU 4. I've given the reference is 001-50. At under business risk, or maybe let's start with financial implications. 001-51. The next page. Financial implications. The list is provided by the Office of the COO and Ops Committee, which is Operations Committee, and contains 215 legends. So from 180 now, we're at 215. The amount approved is at 50,000 rands per legend, a legendary group, and totals the amount of 10,750,000 rands. So and that is all that is being said under financial implication. What you do not find is that there is private funding that will form part of this. You don't find that because there was none. And the allegations that are still being persisted with in this case, that there were private funds procured by Mr. Motsoeneng, they are incorrect. In fact, they are misleading to the court, and we will ask that the court makes note of that. Even if, and this is important, even when we come to the just and equitable remedy as to why the responsible parties must pay, but also with regard to costs. Then the next page. Under business risk, the second bullet point, and I want to explain to show that this business case was not even about the initial approval itself. It was mainly about the increase from 180 to 215. It says the list as per minutes of the meeting was a PAX of 180. However, the list of artists provided by Operations Committee to Radio Division has a PAX of 215 legends. The initial list was reviewed by the Operations Committee after the meeting took place, and the numbers changed subsequently. To avoid maladministration, the final list should be signed off by the parties to the business case. So that is what this business case was about, simply to increase from 180 to 250. And in conclusion, it says, in support of the music fraternity, we request that we proceed to remunerate legends to show gratitude. And this is important. It's got nothing to do with operations of the SABC. It was to show gratitude to the legends and to keep the word given by the SABC. That's what it says. Then the next page, it is signed by three individuals. It's the first respondent, the second respondent, and the 10th respondent on 30th of September. Again, no reference is made to private funding. This was meant to be a supplementary business case to the initial business case that would have served before 5 September, before the decision was made. But we found none, because there was none prepared. So that, my lady, establishes the illegality of the decision, in our view. And perhaps I must refer to, of course, I'll refer to the minutes of 5 September, but maybe let's start with what the respondent seems to be, relying on, and all of them, well, not all of them, but a number of them refer to the section E13 or clause E13 of the Delegation of Authority Framework. And that we find, my lady, at 005-2268. And all that it says is that where you have operational expenditure, and that's the operative word, operational expenditure, meaning expenditure linked to operations of the SABC. So when you have that, and you find that they're not provided for elsewhere in the DAF, the Operations Committee may approve up to 50 million rands. That's basically what it says. But as we've shown, what we're dealing with here, it was a payment characterized as a gratuity, not linked to operations of the SABC. Now, while I'm still at the DAF, I may also refer to clause 7.1 of the DAF. It is dealt also in the supplementary affidavit. But let me give you, my lady, the reference to DAF. It's 005-2241. And I'm going to read what 7.1 says. Where any business activity is not dealt with in the scope of this DAF, or is an exceptional stroke unusual circumstance, The general principle of voluntary upward referral to the individual or committee at the next higher level of authority prior to decision making applies. So, because there is no policy and because this is not part of operations, what the operations committee had to do in those circumstances was refer this to EXCO or the board, not take a decision itself. But it's exactly what they did. Now, the minutes of, and it's important that I refer to the minutes themselves, because what I refer to is the extract of the minutes, but I need to refer to the minutes. If a people just bear with me. Yes, it will be at page 857, according to 859, according to my notes. Let me just get there. And this is now to identify the members of the operations committee that were present. What I've shown so far in relation to the business case is that 3 individuals are involved. It's a first respondent, a second respondent, it's a 10th respondent. They signed the business case, even if they are aware that it makes no reference to private funding and so forth. Now, Annexure VGMM7, it appears at page 005-859. It now lists the 8 members of the operations committee. And we say all these members, in terms of the DAF, that they are liable, and I'll explain why. I've already shown that what they did was to approve. None of them dissented. None of them said, but we don't have a business case here. How can we simply approve that? None of them said, look, Mr. Motsoeneng, you say you are raising private funds. Where are they? And how much are they? None of them. They simply approved. Now, why is that important? And the relevant clause of the DAF is quoted in our heads, the main heads. It's quoted at paragraph 35, now 36. But I want to start with paragraph 35, which deals with the general principles contemplated in chapter 5 of the DAF or clause 5. And I just want to read what we've highlighted at page 007-27. And it reads, generally, individuals or forums empowered to exercise any decision-making authority in terms of the DAF must demonstrate prior to exercising such authority that they have fully considered the risks inherent in the proposed decision, that they have taken all reasonable steps to ensure that such risks are appropriately mitigated, and that they are acting in the best interest of and for the sole benefit of the corporation. At paragraph 36 of the heads, we quote clause 5.3.1, which reads, the delegated authority vested in the delegatees in terms of this DAF is vested in each delegatee as an individual, such that each delegatee shall be personally and individually responsible for the due exercise of such authority and shall be accountable for the consequences following therefrom. Because there's a criticism to say, but we did not benefit, the monies were paid to the legends. Why are you coming after us? But this DAF makes it clear. But this is what clause 5.3.2 says in express terms. Where decisions are made by a committee, each member of that committee present at the meeting at which the decision was taken and who has not dissented shall be accountable and jointly liable, separately and in his or her official or personal capacity for the consequences following therefrom. So the criticism that why are we citing members of the operations committee? There's the answer. They were there, and from the record, none of them dissented. In terms of this clause, they must be held personally liable. And that is what the applicants are doing here. They're approaching that court to say, but these members are personally liable. And it's all on account of this this clause. Now, and I must pause to mention one point. While all the respondents say, but you can't be pursuing me, I did not benefit, I was acting on behalf of the SABC and so forth. None of them is collaterally challenging this clause. None of them. None of them is saying this clause is unlawful. The court should not rely on it. The court should not apply it. None of them. And these are the legal prescripts that govern the SABC and are not to be ignored. They've got to be enforced. Now, and we say there are two categories. We've got members of the operations committee who took the decision and did not dissent. Now they of course come and say, but you can't hold us responsible, and they give a variety of reasons. We say the applicants were entitled to proceed in the manner that they did, in line with that clause, and based on other submissions that I have made. But my lady, even if some of them can show your ladyship that they should not be held accountable for one or various other reasons, we say the three who signed the business case, these are members of EXCO, those have to be held responsible. So firstly, we say all of them, all the respondents have to be held personally liable, jointly and severally. But if any of the members of the operations committee were to convince your ladyship that they should not be held liable, maybe because they were simply bulldozed, as some of them suggest, then we say at least the members of the ESCO, those who signed the business case, and we're talking here of the first respondent, Mr. Motsoeneng, the second respondent, Ms. Rapela, the third respondent, Mr. Agun, those cannot escape. And I emphasize again that none of the parties have challenged clause 5.3.2 collaterally, none of them. Now, just to give references to, because we've heard that the Mr. Motsoeneng, and we'll hear from his legal representatives, but from the affidavits from the heads, it is said that he procured funding from the from multi-choice. Perhaps I must go to what he says in his paragraph, in his affidavit, at paragraph 9, at page 001-80. I'm just going to read in the middle of the page. He says, I raised the...
Sorry, paragraph number again?
Paragraph 9.
Paragraph 9.
Of his funding affidavit at page 001.
Thank you.
-80. He says, I raised funds for the SABC from the private sources, which the SIU, with diligent investigation, would know. That's what he says, in a very cynical manner. Then he proceeds, a section of the money raised from private sector was to reward the music legends for the role that they had played in the liberation struggle and promoting objectives of the struggle, blah, blah. Then he says, I reported this to the board, which endorsed the value of the Once of Recognition project. But we find no evidence of this. He's attached nothing to prove what he says there. what we find, in fact, because he says if the SIU would care to investigate, would conduct a diligent investigation, they will find that out. But it is exactly what the SIU did. They did investigate. After seeing his affidavit that he still persists with that, they then dealt with the issue in the replying affidavit at paragraph 16. At paragraph 60, at page 003, -50, 003-50, paragraph 60. And I'm not going to refer to take your leadership to all the affidavits that they relied upon, but these are individuals involved in the finances of the SABC. And they say, but this is not true. There were no private funds obtained for this. So the deponent says that my investigation revealed that there was no external funding received by the SABC for the Legends matter. In fact, the funding, it came from Cost Center 1721. So this is one of those coded cost centers within the SABC, 1721, not from some outside source. Mr. Mudau is one of those mentioned in this paragraph, and his affidavit is attached, well, is supplied as part of the record. But the deponent says about Mr. Mudau, he says, Mudau confirmed that the funds paid to the Music Legends were from Cost Center 1721, as the Music Legends project was not a planned matter or budgeted for, as it did not form part of the approved annual budget plan at the beginning of the financial year. But then, what is more is that because Mr. Motsoeneng says, but I raised this from multi-choice. At paragraph 62, at page 003-51, now dealing squarely with the allegation by Mr. Motsoeneng. The deponent says, and I'm just reading in the middle of the paragraph, I requested confirmation of this fact from multi-choice, and they indicated that no negotiations took place between the SABC and MultiChoice regarding the Legends matter, and that no payments were made by MultiChoice to the SABC. This confirmed in a letter written by Mr. Brandon Foote on behalf of MultiChoice, which appears as from, it says page 895, but the case line reference is 005-912. 005-912, that's where it starts. It ends at 005-917. So at 005-917, this is not the correct reference, but the letter from MultiChoice, Mr. Brandon Foote specifically expressly says what the deponent says here. Expressly says, no, there were not even negotiations in relation to the Legends matter. We made no payment. So his answer is that we advise that no negotiations took place regarding the above matter, no agreements were concluded, and no payments in regarding to such matter were paid. So that puts paid to any argument that SABC could not have suffered any financial harm because due to this decision, because it obtained private funding. There is no such. All these monies are from the SABC, and in fact, as I've shown in the business case, there's no reference to funding from MultiChoice. Now, I've already touched upon the remedy in a way, my lady, as to why we say we want to proceed against, firstly, all the respondents, but if we fail, then at least the other three, those who particularly sign the business case. But of course, we say, if clause 5.3.2 is to be applied, then all the members of the operations committee are responsible, because none of them dissented. Now, in the note, before I go further with the remedy, in the notice of motion, what is being attacked is two editions. And it is edition of 26 July 2016. It's incorrectly recorded as 24 July, but it's in fact 26 July 2016. But as matters stand, and that was because when one looks at the minutes of 5 September, Mr. Motsoeneng says the SABC intends paying the legends this week. It presupposes that addition would have been taken. But of course, from what we've shown, Your Ladyship, there's no evidence of EXCO taking any decision whatsoever. In fact, in the minutes of EXCO of 26 July, if I may give the reference, my lady, is 005-642. That's where it starts. But the relevant portion is 005-644. Under paragraph 3, general, it simply says that the meeting noted that former music legends who did not qualify under natural time would be honored at a prestigious function at the SABC. The COO announced that funding had been sought to financially honor former music legends, with 50% being borne by external funders. This is the minutes of 26 July 2016, the minutes of EXCO, not the Ops Committee. And that is why in the notice of motion, the prayer 2, it specifically attacks EXCO's edition in case this is seen as the decision to approve the payment, because Mr. Motsoeneng states it as a fact that it will be done and the EXCO simply notes. But this is the only recordal of the discussion of this matter in EXCO. To an extent, this may be construed as a decision that ought to be reviewed and set aside. But what we know as express approval, it is contained in the minutes of 5 September by the Operations Committee. And that is why prayer 1 starts with the 26 July decision. Then prayer 3 deals with the 5 September decision of the Operations Committee. So we say if this is to be viewed as a decision by EXCO, then it's got to be set aside. Of course, Mr. Aguma in his affidavit says the decision was taken by the Operations Committee, but we'll hear what his argument is. Now that being the case, my lady, and perhaps I must make this point. And again, in reference to what Mr. Motsoeneng says in his affidavit. And we understand the plight of the musicians. We understand that, and we do not take it lightly. But all that we are saying, those who are appointed in positions of authority, those who are given fiduciary duties, or those who have fiduciary duties, they've got to act in terms of the law. Mr. Motsoeneng says at paragraph 5 of his answering affidavit at 001-78, and he refers to the Broadcasting Act, and he correctly states what it says. In the middle of the paragraph, it says Section 2A provides for the establishment and development of a broadcasting policy in the public interest and for the purpose to contribute to the democracy, development of society, gender equality, nation building, provision of education, and strengthening of the spiritual and moral fiber of the society. He refers to Section 2A of the Broadcasting Act. Then he refers to Section 2R, which requires the adoption of a policy that would encourage the development of local programming content. But that is exactly the issue. The Act says develop the policy to pursue these objectives. Develop the policy. Once the policy then is approved, the SABC will act in accordance with the policy. But you don't simply make a decision, ignore the policy, ignore the law, and simply make a decision, and the SABC must pay. That's what we say. So we understand the plight of the musicians, we understand that, but we're saying these officials acted wrongly. Acted wrongly, because if there was a policy and if there was a proper budget, then all these things would have been done lawfully, knowing exactly what the budget is. So, my lady, that concludes our argument on the legality or perhaps lack of legality of the decision and the remedy. Well, the remedy, I must emphasize again, I've already made the submission. I've already made the submission that we say all of them are liable, but if for any reason your leadership is convinced by any member of the operations committee that they should not be held liable, at least the other three. And there is an accusation, I'm sure we will hear, that we have not set out specific facts or facts specific to each respondent as to why that respondent should be held liable. We did not need to do that. Clause 5.3.2 is clear. You were part of the committee approved, you did not dissent. Now the onus is on you to tell us otherwise. It's not upon us to go look at facts as to why, in addition to what DAF says, you should be held liable. No. Based on what DAF says, we're entitled to come before court and say, here's the minutes, you approved, not dissenting, therefore you're liable. So they are all liable, my lady. Then, in our supplementary heads, we deal, because the leadership would have noticed that there is a counter application. And perhaps I must just say something on it, not simply deal with it in reply. In our supplementary heads, we deal with it at paragraphs 27 to 34. And by the way, my lady, I've noticed, unless if it's been uploaded most recently, but I've noticed that we don't have the signed affidavit of the 8th and 9th respondent on case lines. And what we had to work on that was served previously, in fact, differs slightly with what is on case lines. And that is something, we are not taking a point that they should not be heard, but it's something that they must simply correct and file the correct one, the signed one. We are not taking a point on that. We simply point that out because the court cannot make a ruling without a properly signed affidavit. All that they must do is simply upload it on case lines. Now, my lady, the counter application. And firstly, we say that the tribunal has got no jurisdiction to deal with the counter application, because what is being attacked is the internal forensic report of the SABC, even before the tribunal was appointed. I'm sorry, even before the SIU was appointed. And we're not here asserting the findings of the SABC internal forensic report. We are here asserting the findings of the SIU, various affidavits that they've placed as part of the record. That is why we're here. The tribunal has got a jurisdiction to deal with matters that emanate from the investigations by the SIU. not some reports that would have been procured before the SIU was even appointed. So we say the tribunal does not have jurisdiction. Section 21B is quite clear. It's empowered to adjudicate upon justiciable civil disputes emanating from any investigation of any SIU. But there's a second issue, and is that even if, for example, that report is set aside, so what? So what? Because it takes the matter no further. Again, we rely on our investigations and on investigations of the SIU, and we rely on the affidavits found by the SIU. Why then are we concerned about this counter application? But then, of course, we in our heads we identify a number of paragraphs that ought to be struck out of that affidavit, because we are told about events that happened some time ago. One of the attorneys from Flexman's attorneys, Mr. Sandile July, about matters that really belongs in the labor court. Matters that have got nothing to do with what we're dealing with in this case. There's also a request that my attorney should be marked with costs on a punitive cost, a cost scale, the bonus properties. There's no allegation against her in the affidavit, not even a single allegation that justifies why she must be marked with costs. Whatever complaints they had against Mr. Sandile July, he's not cited here. He's not part of the respondents. But my attorney, Ms. Kosima Basu, she's mentioned there that she must pay the cost, but for what? So we say all those allegations, they are firstly inappropriate, they are irrelevant, they are vexatious, they've got to be struck out. But that is only if the court finds that it has got jurisdiction to even entertain this application. And as we say, it should not adjudicate on that. And your leadership would have noted, in fact, what the counter application seeks is that it must be heard by the full bench of the tribunal. A very odd prayer. Again, no justification why that is necessary, why this court sitting here cannot deal with it if they were married. It's got to be heard by the full bench of the tribunal. It honestly does not make sense. It is a nonsensical application, is very absurd to the extreme. And with respect, it should not be entertained in this matter. But for that, we will ask for punitive cost scale against the 8th and 9th respondents. So it ought to be dismissed on a punitive cost scale. And my lady, that concludes our arguments. I'm not sitting with my attorney and my junior. I wonder if the court can grant me just 2 minutes to hear if there's something that I've forgotten that they may remind me.
I think this is a perfect moment to take the tea adjournment, Mr. Motepe. It's now 5 to 12. We will return at, no, it's almost 12.
Yes.
I see it's almost 12. We will return at 12:15, and I'll give you a few minutes when we come back to round up your argument.
Thank you, my lady.
Thank you. We adjourn for tea.
Yes, my lady, just a quick one. Boss, I understand Mr. Motepe is raising issue, but I think he was not there at the last time when this matter was, when we brought the application for condoning the late filing of the respondents, answering affidavit and the issue of the counter application, of course, is going to be dealt with today. Suffice to say that you did grant condonation. I don't know why he's asserting the issue that what was uploaded was not the signed copy, because the court had sight of the signed copy. If he's taking issue with that, we can upload, but I think that issue was already addressed. It's the same contents, just that suffice to say that it's, I think, on the uploading of the document, the attorney might have uploaded the unsigned copy, but the signed copy was addressed with this court, Your Lordship.
I've made it clear, my lady, I'm not taking any point. I'm just simply saying they must upload the signed copy. I'm not taking any point on that.
Thank you.
As a court, please.
There might be one or two players that are over 30. He has got his reasons. I'm going to ask him the questions. I'm going to ask him, Coach, why is there a 30-year-old? Why is there a 32-year-old in the squad? But I'm looking forward to it. And I think the feeling in South Africa, we feeling hard done by because of the decision that was taken by FIFA. We're still feeling hard done by that decision. But we can see
I am representing some of the families of the deceased in this inquest. Just for clarification purposes to begin with, Professor, you have a doctorate in health sciences nursing, is that correct?
Yes, you are correct.
And you also have a master's in
Thank you. Thank you, Mr. Butlander.
Thank you, my lady. My lady, as your ladyship knows, I appear for the 7th respondent, Mr. Guana. And your ladyship will know the stance that Mr. Guana takes in this matter. She abides the review relief because she is no longer an SABC official. And as she says, she had only a peripheral involvement in the decisions concerned at all. And so she abides the review relief, and her only interest is in the claim for repayment.
Sorry, Mr. Butlander, I've got a bit of interruption here. Sorry.
No problem, my lady.
Thank you. Sorry about that.
Thank you, my lady. So Mr. Guana, as I say, she's now retired. She is 67 years old, having worked at the SABC for 20 years. And she has no interest in the review relief, and she abides it. Her interest is only in the repayment relief. And that is the proposition that she should now be required in her personal capacity to pay millions of rand back to the SABC. My lady, I want to address 3 different issues in the same way as we've done in the heads, but in doing so, I want to address the new arguments that our learned friends have made, because make no mistake, my lady, what your ladyship has been confronted with is a very different set of arguments that were advanced previously, and a set of arguments which I'm going to demonstrate to your ladyship. Many of them are wrong in law, and others are simply impermissible on the pleadings. So the 3 issues I propose to address is, firstly, I want to deal with prescription, because if prescription is good, then the question of undue delay doesn't arise in respect of my client, because, as I say, her only interest is in respect of the repayment relief. Undue delay. And finally, I will turn to deal with the merits of the claim against her, the repayment claim. So can I deal with prescription, my lady? And we have addressed prescription in our heads of argument from paragraphs 12 all the way through to paragraph 20. And with respect, our learned friend has been studiously silent on most of those principles. I'm sure your ladyship has read the heads, but could I summarize them briefly just to make sure that they're on the table? Because quite curiously, our learned friend has not dealt with them. We make the point that the Prescription Act provides clearly that the period for most debt is 3 years, and that period starts running as soon as the debt is due. We make clear that it is common cause that the payments in issue, which are sought to be recovered, were payments made between October 2016 and February 2017. That's paragraph 13 of our heads. And we make clear that the present application was only launched in January 2021, well over 3 years. So on ordinary principles, your ladyship knows what the Prescription Act says. It says, upon the expiry of 3 years, the debt shall become prescribed. It is a mandatory provision. It is in imperative terms, and it is quite clear. Now, the arguments which were advanced previously, which apparently are no longer advanced, but which we have dealt with in the heads, the first was the argument that said, well, the SIU is somehow in a better position from a prescription point of view. We deal with that in paragraph 17, and we explain that the authority of Kim Diamonds is dead against that because the SIU steps into the shoes of the creditor, and so it's in the same position. So that argument which was made is no good. The second argument is to suggest that prescription could only begin running when investigations were concluded, and that seemed to be an argument based on section 12.3 of the Prescription Act. But as we explained again, that cannot be good either. This is dealt with in paragraph 18 of our heads. That can't be good because it's common cause that the SABC received a report pursuant to forensic investigation as early as 3 August 2017. And that report said that the decision was irregular and breached the PFMA, and that the operations committee had to be held accountable. And that was then reported to the SABC Exco on 14 September 2017. So what that means is that at the very latest, the relevant facts had come to the knowledge of the SABC by 14 September 2017. And of course, the application is only launched in January 2021, 3 years, more than 3 years thereafter. And so it is prescribed. That is true of the SABC. It is also true of the SIU because of Kim Diamonds. So that second argument is no good. The third argument was to say, well, prescription can only start running when the impugned decisions are set aside. And so you have to first set them aside and then you claim back. But that, with respect, my lady, is to misunderstand the position. And the correct position is in fact explained well in a case which I will give to your ladyship in a moment and which we have not referred to in the heads. Give me one moment. I have inadvertently closed the relevant page. I'm going to give your ladyship a constitutional court reference because it makes the point rather neatly, but it in turn refers to the SCA decision. If your ladyship would give me one moment. The case I wish to refer your ladyship to is called Motsoeneng versus Minister of Police, 2018, volume 5 of the South African Law Reports, page 22. And in that judgment, the court deals, that case is not itself on point, but it goes on to deal with a previous case of the SCA, which is extremely helpful, and the court summarizes its effect. Let me just find it for you, if I may. I do apologize, my lady, I closed the passage at the exact wrong moment. It's paragraph 51 of Motsoeneng, and in paragraph 51, Justice Zondo, as he then was, discussed the SCA's decision in Fluxmans. That is the discussion of the decision in Fluxmans versus Leveson, 2017 to SA 520, a decision of the SCA. And that was an enrichment claim. And the question was, does prescription in respect of unjust enrichment start running when the payment is made? Or does it start running when the contract is declared invalid? There in a private law setting, but nevertheless. And the Constitutional Court summarized the position as follows. It says the most recent judgment of the SCA, which has confirmed that Section 12.3 does not require knowledge of legal conclusion on the part of a creditor before a debt can be said to be due, is Fluxmans. Both the majority and the minority judgments were agreed on this. That an agreement is invalid is not a fact, but a legal conclusion. That seems to be the same as to say that conduct is wrongful and actionable is a legal conclusion and a fact, and not a fact. In other words, the SCA saying, and the Con Court endorsing it, that the question of whether an agreement in that unjust enrichment context was invalid is a question of fact, not law. And so the question of when it's declared invalid is neither here nor there. Similarly here, if the resolution is invalid, the resolution of the operations committee, that is not a question of fact but law, and so it doesn't start prescription running again. So we didn't refer to Motsoeneng or Fluxman versus Leveson, but it is very much authority for the point that we make in paragraph 19. So those first 3 points that are made in answer to prescription and which apparently are not persisted with are not sustainable. We are then left with really one new point, which is made today. And that is the new point, which is to say, no, prescription doesn't apply in a public law setting. Because the argument goes, this is like estoppel. And your ladyship was given the reference to contract props, the well-known decision of the SCA, which held that estoppel couldn't operate to found liability or avoid a defense in a public law setting. And so the argument goes, no, prescription is a private law concept, that was my learned friend Mr. Motepe's language, which has no application in a public law setting. My lady, firstly, there is no authority for that proposition at all. None was given to you, and none exists. But more importantly... I was given Gijima. No, but Gijima, with respect, was about the delay point, not about the prescription point, at least as I understood it. Gijima was about undue delay, and the notion that the contract must be reviewed and set aside even if there's been delay. My learned friend, quite rightly, and he was right to do so, sought to draw a distinction between delay on the one hand, beg your pardon, between the review on the one hand and the repayment relief on the other. And Gajima, I accept, and I will come to it, is relevant to the question of undue delay regarding the review. And I accept that that's different. I'm now on prescription squarely, the question of whether one can claim a debt after all of these years. And Gajima is not authority for that proposition and was not said to be authority because Gajima did not involve the claimant for repayment of a debt, and neither did Buffalo City.
Does that principle not extend, though, to prescription? Because if a decision is impugned on the basis that it is unlawful,
yes,
because the bearers of the public authority exercised an authority they do not have,
yes,
doesn't that consequentially apply to the other steps taken in persuasion, in pursuance of that decision? I think I've lost.
The reason is I'm sorry, my lady. I do apologize.
Yeah,
can you, lady?
Sorry, you keep freezing.
My lady, would you give me one moment? I don't know why I'm having network issues today. Would you give me one moment to see if I can change networks and see if that helps?
That's fine.
I'll literally be 30 seconds.
Okay, that's fine.
Can your ladyship hear me now?
Yes, we'll see how it goes. Your visuals are still blurry, which indicates that the problem persists. Let's just see how it goes. Yes.
All right. Please do tell me if you can't hear me, my lady, and I will try and make another plan if needs be. Yes, but let's try and see how we go.
Okay.
So, my lady, the point I was making is that proposition is not correct because the Prescription Act is emphatic. It says that prescription in respect of any debt, leaving aside certain exceptions, debts owed to the state and certain other things, prescription in respect of any debt shall occur 3 years after the debt became due. Now, that is very expressly what the Prescription Act says in terms. And if I could just give your ladyship the reference to that, it's section 10(1) of the Prescription Act. And it says, subject to the provisions of this chapter and chapter 4, a debt shall be extinguished by prescription after the period in terms of which the relevant law applies in respect of prescription on such a date. So shall be extinguished is the language. And then it goes on to deal with the period. And of course, we all know it's 3 years, and we know when it commences to run. Now, what my learned friend has not been able to explain to you is how that is changed in a public law setting. He has given you no, is he saying this isn't a debt? Is he saying the debt doesn't become due? If he is saying it's not a debt, why is it not a debt? If he is saying it doesn't become due, why doesn't it become due in light of cases like Fluxmans versus Levinson as approved by the Con Court? So with respect, he must do more than say that this is a private law notion which is inapplicable in a public law setting. There is simply no basis upon which he's argued that that would be the case. So let me say also, my lady, that
case is that the debt became due when? Because you referred to the 2016 payment.
Yes, that is when the debt became.
Reference to the forensic report and when it was presented to the board. So yes. Precisely at what point do we start calculating prescription?
Let me say this, my lady. On the ordinary approach, the debt would become due on the date of the payment, because when you pay the money unlawfully, then that is the date that the debt becomes due.
But at that point, is there any knowledge of unlawfulness at that point?
No, precisely. So that's the ordinary starting point. But then I accept, of course, that there may have been no knowledge of unlawfulness. But then at the very latest, the debt must have become due by the 14th of September 2017. And you see that from our heads at paragraph 25.3. Because by then, you have an interim SABC board appointed. That's March 2017. It tells the SABC's forensic team to conduct investigations and produce reports. And this is all paragraph 25 of our heads. On 3 August 2017, the SABC's own forensic investigation determines that the decision to make the payments was irregular, that it breached the PFMA, and that the OPCO must be held accountable. That then gets discussed 6 weeks later on 14 September 2017 by the SABC Group Exco. So at the very latest, when that report served before the SABC Group Exco, the SABC cannot say that it didn't have knowledge. It had knowledge by then, unquestionably. And under those circumstances, the debt commenced running.
Yeah, I'm not satisfied with your response to the issue that I've raised in respect of the principle in Gijima.
Well, my lady, I'm sorry.
Yes.
My lady,
the consequences of the same decision. So are you saying simply because the SABC did not institute action when it gained knowledge of the unlawfulness on the 14th of September 2017,
yes,
the consequences that flow from that unlawful decision cannot be reversed? And hence I find resort to section 1721A appealing.
But my lady, with respect, 1721A and
Yes.
1721B cannot be a basis for ignoring the peremptory provisions of the Prescription Act. And that's why I go, you see, because that's why in Gijima, let me deal with the consequences of the argument, if I may. If your ladyship is with me for a moment, just to assume that prescription has occurred, but let's say that your ladyship is against me on undue delay. So you accept that the case was brought more than 3 years after the debt arose, but you say that in the circumstances that was not an undue delay. Then what are the consequences? Well, then your ladyship can still grant the review relief. Your ladyship can review and set aside the decisions. And my learned friend, Mr. Motepe, tells you why that's important. It's to prevent future claims and all sorts of things. But what your ladyship cannot do is your ladyship cannot, in those circumstances, direct that individuals repay those monies, because that is the debt.
Just think about the rationale of the approach you want me to take.
Yes.
So when it comes to the review, a delay is of no consequence. But when it comes to the decisions that flow from the review, and in this case is the payment of the money and the loss to the state consequent upon that decision, then the unlawfulness cannot be reversed. Because remember, the whole purpose of section 1721B, it gives the court very, very wide discretion to reverse the consequences of an unlawful, of unconstitutional conduct.
Yes.
So are you saying in this case, it's okay to condone the delay, but because there was a delay, because prescription is really a delay point, right?
Yes.
If there was a delay in reclaiming the money, then that delay should not be excused. It's okay to excuse it only to declare the conduct unconstitutional, but the loss to the state remains.
Yes, that is in fact exactly what happened in Gijima. Because when you read Gijima, what the court did is it drew a distinction, and it's what happened in Buffalo City. In both of those cases, and I'll take you to the passages now, what happened in both of those cases is the court said, we are not going to let delay preclude us from getting to the review relief, because we are duty bound to deal with the review relief in terms of 172(1)(a). But we are going to make clear that this will not affect rights that already vested. In other words, the fact that you did an illegal contract, the fact that rights were required is not changed. Could I take you to the judgment to demonstrate that? So in fact, my submission is that Gajima and Buffalo City, the two decisions on which my learned friend relies, in fact, strongly support the distinction between review relief on the one hand and the repayment relief on the other. Could I demonstrate that to your ladyship, if I may? If your ladyship looks at the section on, so the bulk of the Gajima judgment, paragraphs 1 to 49, deals with the question of delay. And it deals with whether delay should be condoned and should it be reviewed. And then in paragraphs 52 to 54, the court explains what its conclusion is. It says, and I apologize for reading it in some detail, but it is important. We concluded earlier that in awarding the DoD agreement, CETA acted contrary to the dictates of the Constitution. Section 172(1)(a) of the Constitution enjoins a court to declare invalid any law or conduct it finds to be inconsistent with the Constitution. The award of the contract thus falls to be declared invalid. In other words, the review relief. So the court says delay won't stop us getting to the review. But then the court says, however, under 172(1)(b), a court deciding a constitutional matter has a wide remedial power. It is empowered to make any order that's just and equitable. So wide is the power that it's bounded only by considerations of justice and equity. Here it must count for quite a lot that CETA has delayed for just over 22 months before having the decision reviewed and set aside. Also, from the outset, Gajima was concerned whether the award of the contract complied with legal prescripts. As a result, it raised the issue with CETA repeatedly. CETA assured it that a proper procurement process has been followed. And then in paragraph 54, the court says, overall, it seems to us that justice and equity dictate that despite the invalidity of the award of the DoD agreement, CETA must not benefit from having given Gajima false assurances and from its own undue delay in instituting proceedings. Can I just pause there? If I was to apply that to this case and put in the appropriate parties, overall, it seems that justice and equity dictate, and indeed the Prescription Act dictates, but justice and equity dictate that despite the invalidity of the Operation Committee's decision, the SABC must not benefit from its own delay in instituting the procedures. And then the court goes on to say, we're going to make clear that the declaration of invalidity does not have the effect of divesting Gajima of rights to which it would, but for the declaration of invalidity, might have been entitled. And then when you read the order, paragraph 3b of the order says exactly that. 3a says it's declared constitutionally invalid, and 3b says the order of constitutional invalidity does not have the effect of divesting the respondent, that's Gajima, of any rights it would have been entitled to under the contract, but for the declaration. In other words, in that case, Gajima and CETA enter into a contract. CETA says we will pay you 100 million rand, or whatever it was. That decision is declared invalid, but the court says that doesn't preclude Gajima from suing for the 100 million rand from the state. So it draws a distinction exactly, my lady, between the review relief and the consequential relief, and says you might exonerate them from delay on the review relief, but delay remains relevant to the consequential relief. Now that, of course, was not about the Prescription Act because it was not a claim for damages, but it's the same concept. And then when you go and read Buffalo City, which is, of course...
Before you move to Buffalo City, Mr. Butlander, I've grappled with that paragraph in Gajima a lot because it's often relied on in the tribunal when respondents would like to escape liability by way of a just and equitable remedy. Now, when the court makes reference to CETA not benefiting, did the court there rely only on the delay, or did it also rely on SITA's conduct in constantly assuring Gijima that the contract was above board? Did it also rely on very peculiar facts of that case, that Gijima was actually enticed into agreeing to the termination of a contract that was lawfully awarded, to accept appointment under a contract that was subsequently declared invalid in SITA versus Gijima?
Yes.
And didn't the court say, this is we are compensating you, Gijima, because if you were not enticed into accepting termination of a lawful contract in exchange for one that is actually unlawful, there are monies you would have earned. And if we don't allow you to benefit here, you will lose that money. So there were very peculiar circumstances that are not present here. I don't think the court only relied on the question of the delay. It was a conspectus of factors.
Yes. No, my lady, your ladyship is absolutely right. And I cannot disagree with that for a moment. But I was making a somewhat different point. Your ladyship put, and I accept that the facts of this case are distinguishable for all, but your ladyship put to me the proposition,
yes,
that it can't be right, and I hope I'm summarizing it fairly, that
yes,
it can't be right to say we're going to exonerate you for delay on the review and then find our hands tied on the consequential relief. The
yes,
point I was making is that both Gijima and Buffalo City adopt that approach, albeit on the facts of those cases,
yes,
and albeit under 172(1)(b, and albeit without reference to the Prescription Act. They both say the fact that you allow the state to delay unduly and still review doesn't mean it follows that delay is irrelevant when it comes to the question of an appropriate remedy. That's all. That's the only proposition. I don't mean that delay in every case will put an end to it. That's not my proposition. My proposition is simply that it doesn't follow that because you let the SABC and the SIU in the door, despite delay, to argue the review, that they are necessarily in the door for the repayment relief. And that's the crisp point I wish to make. And if your ladyship accepts that proposition, and I submit that your ladyship should, then one is into the Prescription Act, because the Prescription Act governs the repayment of all debts. This is a claim for payment of a debt. That claim prescribed in 2017, and your ladyship, whatever other relief your ladyship wishes to order, should not order repayment. And let me give you the sorts of examples that your ladyship of relief that your ladyship could still award in appropriate cases. Your ladyship could award relief directing that officials are to be subject to disciplinary action and they might be fired. Your ladyship, if the suit is against a company, your ladyship could direct that the company be blacklisted. Your ladyship could direct a whole range of relief under 172(1)(b, but the one thing your ladyship could not do with respect is direct that a debt be repaid when that claim had prescribed. So I rely on Gijima and Buffalo City for that narrow proposition, that it is not untoward or unprecedented to separate out the review relief and the consequential relief in dealing with the question of delay.
So you are saying here, simply on the basis that there was a delay,
yes,
I should just apply the Prescription Act and absolve Mr. Wanu. There are no other factors you rely on.
Yes, and in fact, I'm saying I'm not relying. I'm going to come in a moment to the fact that there was prejudice to Ms. Tugwana in the delay, and I'm going to come to other things. But my respectful submission is that the Prescription Act remains binding. It is binding because Section 10 says that after a debt has become, after the 3-year period has been met, the debt is extinguished by operation of law. And there is nothing in the Prescription Act or the Constitution that allows your ladyship to ignore with respect that provision. And so I don't need, for purposes of the prescription argument, to go any further than I have. And of course, there might be cases in other days. Let me give your ladyship an example. Under a malevolent board, and they make payments to someone or an unlawful tender, and they investigate it and they find that it was wrong and they bury the investigation. And in fact, the new board gets in, and then the new board sues or reviews. In those circumstances, it would be open to an organ of state to plead, but hang on, 12.3 doesn't apply in these circumstances because we are a different entity in a sense. We didn't have knowledge of the facts, and they were precluded from coming to the attention by the malfeasance of the officials. That's not the case made here. There is no attempt made here to say the reason that it took more than 3 years from 14 September 2017 was because Mr. Motsoeneng prevented it, or because there was no new board in place. If those were the facts, we might have a different case, because Section 12 of the Prescription Act gives plenty of flexibility because of where it says, for example, that a debt shall not be deemed due until the creditor has knowledge. That it makes absolutely clear that there are ways, that there is flexibility. But that's not the case here. They have not. We pleaded prescription squarely, and they did not at any stage plead those facts. And that's why this case is a simple case with respect, because if your ladyship accepts, as I submit you must, that prescription commenced running at the latest on 14 September 2017, which was the date on which the forensic report was discussed at the SABC Group Exco, with an interim SABC board already in place, and with the forensic investigation having been done, then with respect, that's the end of it. And your ladyship knows that under the Prescription Act, there is no condemnation, there is no justice and equity in that way. It is a guillotine. It is a guillotine that operates unless you're in a 12.3 world where there's someone who's...
about the supremacy of the Constitution, Mr.
But with respect, my lady, then the SABC and the SIU must challenge the constitutionality of Section 10 of the Prescription Act. They must say that the Prescription Act is unconstitutional. And they haven't done so, despite the fact that the Prescription Act was squarely raised. And what that means is that Section 10.1 says that this debt was extinguished by prescription 3 years from 14 September 2017 at the latest. And if they wish to take issue with that, they must explain, they must challenge it. And they must say it's insufficiently attentive, or it ties the court's hands, or it does, but they haven't done so. And maybe another case will come one day, and there'll be lots of arguments. But for the moment, as your ladyship knows, if a statute has not been challenged, it must be taken to be constitutionally valid. And if your ladyship requires authority, I can provide authority for that proposition. But that is where we are today.
Okay, please provide me with authority for that proposition.
Certainly, my lady. I will provide some for you. Just let me make a note. I'll mention it later in the course of the hearing, if I may, my lady.
Thank you.
So, if I could just say one word about Buffalo City for the same reason, because Buffalo City does exactly the same thing. It spends the first 101 paragraphs on the question of whether the delay should be condoned. And it comes to the conclusion that Justice Theron, speaking for the majority, comes to the conclusion that the delay effectively should not non-suit the review. But it then does come to the question of relief. And what it says is, if I can just find the relevant paragraph, paragraph 105, it says, in these circumstances, justice and equity dictate that the municipality should not benefit from its own undue delay, and in allowing the respondent to proceed to perform in terms of the contract. I therefore make an order declaring the recent contract invalid, but not setting it aside, so as to preserve the rights that the respondent might have been entitled to obtain. So it should be noted that such an award preserves rights which have already accrued, but does not permit a party to obtain further rights under the invalid agreement. Now again, your ladyship will say to me with force, but that is not, the facts are not identical, and I absolutely accept that. But it's the principle about the difference between delay for the review and delay for the consequential relief, which I cite Buffalo City as authority for.
Yes, proceed.
Thank you, my lady. So that really deals with the prescription point. Let me just say one more word on it, and that is that this notion that contract props assists, it doesn't assist with respect. Contract props was not about a statute. Contract props was about the common law doctrine of estoppel. And the court had to deal with whether a common law doctrine of estoppel could result in the enforcement of a contract which was contrary to a statute. So there you had a contract and you had a lease, and the lease had been concluded in violation of a statutory prohibition. And the argument was, we want to carry on and enforce that contract, and we want to rely on estoppel. And the court said, don't bring me your private law doctrine of estoppel, where this is invalid in terms of a statute, because it's simply a common law doctrine and it gives way to the statute. It doesn't, it's plainly not analogous to the situation we've got here, where the debt is extinguished by virtue of a statute, and that statute has not been challenged. And as I say, I will give your ladyship the authorities in a moment about how, if it's not been challenged, it must be treated as valid. Thank you, my lady. My lady, there is then the question of undue delay. I don't want to spend much time on that because many others are going to spend time on it. I do just want to make the point that the notion that the claim that there was no prejudice pleaded by my client is wholly without merit, and that your ladyship will see, if I can give your ladyship the case reference. It is 002-114, paragraph 19. 002-114, paragraph 19, where my client, under the heading of undue delay, says, it is self-evidently prejudicial for an official such as me to be confronted with this claim well over 3 years after it arose, and in circumstances where I have retired from active employment. I've had to rely on my limited retirement resources just to defend this matter, and even then had only been able to do so because my attorney and counsel have agreed to charge reduced rates. Indeed, the attorney is now entirely pro bono, and me virtually as well, but that's just a gloss. The notion that I should now, in addition, pay money to organs of state long after the debts concerned arose is plainly prejudicial. With respect, the suggestion that there's no prejudice to my client as a consequence of the delay is without merit. Lastly, there is no basis with respect for the suggestion that if your ladyship doesn't deal with the question of delay, if your ladyship doesn't deal with the review, then the SABC is going to be sued for 8 million rand. So you heard my learned friend's argument, which said, well, it's not just the 2 million that was paid. We're very worried that we're going to, for the 8 million that hasn't been paid yet by the musicians. But my lady, with great respect, that is sheer speculation, because those claims would undoubtedly have prescribed. The decision to pay them was made in 2017. We're now 5 years down the line. There's no suggestion that litigation has been instituted. That's the first reason that point is bad. But the second reason that point is bad is that even if they were sued, assume tomorrow that Mr. X, a musician, sues for the 8 million or his share of it, and assume that somehow prescription didn't operate there, it would be open at that point to the SABC to collaterally challenge the decision relied on by Mr. X. So the SABC could then collaterally challenge it under administrative law. Why do I speak about collateral challenges? Because collateral challenges are challenges brought in response to a claim like that. And in a collateral challenge, the delay rule has no impact. And that is made clear by the Merafong judgment. Can I, ladyship, the reference? It's Merafong City, local municipality, versus Anglo Gold Ashanti, 2017, volume 2 of the South African Law Reports, page 211, at paragraph 69. And there, Justice Cameron for the majority says that in these cases, which we may call a classic collateral challenge, delay plays no role. The subject is entitled, as of right, to scrutinize the lawfulness of coercive action. So, in other words, assume that tomorrow Mr. X launches a claim for 8 million rand. The response of the SABC would be, number one, your claim's prescribed, goodbye. But number two, even if your claim hasn't prescribed, we counterclaim to challenge the validity of the resolution on which you rely. And don't tell us about delay, because delay plays no role in a collateral challenge, a challenge brought in response to a claim. And once that is so with respect, there can be no prejudice to the SABC of non-suiting them beyond the loss of the 2 million. But it's not about your ladyship opening the door to another 8 million being claimed. That, with respect, is without any merit.
I'm trying to understand the relevance of the point you're now making, because she takes no issue with the review.
No, she takes no issue with the review because it doesn't affect her. But the review is the gateway through which they try to.
How does the further claims affect her, given that she's quite happy with the decisions being set aside?
Yes.
So if those decisions are set aside,
yes,
the default position is that no consequences should flow from them, and that's her case.
No, I have no, not me. My client has no difficulty with that. I was merely trying to answer the point, the suggestion that if your ladyship doesn't allow the review, that somehow calamity will befall the SABC. And I was saying calamity will not befall the SABC. But I agree with respect that delay is not my main point, and that's why I don't intend to say anything else on it. My main point is prescription. I've made that point, and I think I can now move on to deal with the merits of the claim, if I may.
Okay.
Thank you. So, my lady, that is the third point I wish to address, which is what is the merit of the claim against Ms. Tugwana? And what you've been presented with today is a case which is entirely unlike the case which has been pleaded. Because the case that you have been presented with is that the reason that Ms. Tugwana is liable under the present for the present repayments, or for the repayment, is a clause of the Delegation of Authority Framework, 5.3.2. My learned friend read it to your ladyship, and he must have said it, and I say no disrespect, he must have said it 5 times, maybe 10 times. 5.2.3 was the focus of his claim, and I can understand why. Because 5.2.3 of the Delegation of Authority Framework seems to suggest, somewhat extraordinarily, that if you make a decision, you are jointly and severably liable for it, for all of its consequences, forever, without showing bad faith, without anything. It seems to say that. Now, my lady, that's a very interesting proposition, and one that the courts will have to debate one day. But it cannot be this case, because 5.2.3 was never pleaded in this case. Not once. And I wish to demonstrate that to your ladyship, if I may, by taking your ladyship to what we say in our heads about the case on the repayment relief. Could I ask your ladyship to go? Well, your ladyship need not, well, it might be convenient to go. If I could ask your ladyship to go to the heads, our heads, paragraph 39. We begin by saying that they devote virtually no time to the position of each of the 10 respondents. That is a problem, my lady, because ordinarily the principle is you've got to show bad faith, you've got to show mala fides, etc., but they haven't remotely tried to do that. But then over the page, and this is more important, if your ladyship would turn to paragraph 43 of the heads of argument. We say in paragraph 43, the founding affidavit is extremely thin on the question of repayment relief. The founding affidavit merely contains a bald assertion dealing with the 10 correspondents collectively that, and then we quote it, the respondents in taking the decision collectively acted in flagrant disregard to the first applicant's internal policies, and their conduct in making the decision constituted an abuse of power and they were reckless and grossly negligent in the performance of their official duties. Well, that is the sort of thing one ought to plead if one seeks personal liability of officials. But that case hasn't been advanced before, Your Ladyship. And it hasn't been today. And it hasn't been advanced because the facts don't demonstrate it at all. It's a bald assertion. And we demonstrate in the heads from paragraphs 45 all the way through. I won't read it all to Your Ladyship, all the way through to paragraph 60, that in respect of my client, it's a hopeless case on the facts. So that allegation is not really persisted with. If it's tried to be resurrected in reply, I will consider my position, but it's not really advanced. Then the founding affidavit, and I'm now at 43.2, then the founding affidavit boldly asserts, again dealing with the 10 respondents collectively, that, and we quote, "It is the applicant's submission that the money which the SABC has paid in line with the impugned decision must be recovered from them jointly or severally because they were in a position where they knew or ought to have known how decisions are made within the SABC." So that seems to be importing a mere negligence standard. But that hasn't been argued either today. You haven't heard a word on that. And again, if that's tried to be resurrected in reply, I will consider my client's position. So that's all the founding affidavit says on the repayment relief. The supplementary affidavit, which we explain in paragraph 44, doesn't deal with the repayment relief at all. So the only two propositions advanced for the repayment relief just don't deal in any way with the sort of argument that we've been faced with today. But it gets worse, my lady, because when I heard my learned friend's argument, I was concerned that I might have missed inadvertently references to paragraph 5.2.3 of the Delegation of Authority framework, and that I might have done so in preparing for this matter, and that they were somewhere in the papers. So I went back through the founding papers, my lady, and the supplementary papers, and I can tell your ladyship that there is simply no reference to 5.2.3 in the founding papers or the supplementary papers at all. There are various references to other clauses of the Delegation of Authority framework, but not a single reference to 5.2.3. Now, why does that matter, my lady? Well, it matters because my learned friend is not relying on 5.2.3 as being a basis for the unlawfulness, for the review relief. He is relying on 5.2.3 as being a basis for the liability. It is an essential part of his case for the liability of my client. And it is not pleaded, not in the founding papers, not in the supplementary papers. And that is despite the fact, as I say, that there are various other references to aspects of the Delegations of Authority framework in the affidavit. So if I could give your ladyship an example. At 002-16, paragraph 11, there is a reference to the Delegation of Authority framework, 002-16, paragraph 11. But it is a reference. There is no specific reference to any provision. Then 002-16 says the DAF delegations are rooted in approved policies, but nothing further. At 002-17, there is a reference to paragraph 5.8.3 of the DAF, but that's not relied on. At paragraph 14, there's a reference to paragraph 7.1 of the DAF. In the next paragraph, there's a reference to 6.27 and 11 of the DAF, then column E13 of the DAF. In other words, there are various references to the DAF, but not 5.2.3. So when my learned friend says to your ladyship, but nobody's challenged 5.2.3, well, of course not with respect, because it was never relied on. And I can tell your ladyship that if it had been relied on, we would have challenged it. Because 5.2.3 seems to impose a strict liability on every member of any committee who approves something under the Delegation of Authority framework. In other words, even if you did it in good faith, even if you did it because it was a good decision at the time, even if you did it because you were misled by Mr. Hlaudi Motsoeneng, That's a fairly theoretical proposition I'm putting. But whoever, for whatever the reason, no matter the reason, you are jointly and severally liable. Now, my lady, that is an extraordinary proposition. And it is one that is in violation of many, many provisions of the Constitution. And in fact, it goes back, my lady, to provisions which used to hold directors personally liable for decisions that were taken and that were challenged and set aside, to the best of my recollection. I haven't had a chance to look them up, but I think it was cases like Bernstein versus Bester. But I will find that no, it was S versus Coetzee. In S versus declared invalid provisions which held directors personally liable without a fault requirement. Now, that was in a criminal context, but this has the same effect in a civil context. So if this had been relied on, we unquestionably would have challenged it, but it was never relied on in the papers. And I hardly need to tell your ladyship that in an application proceeding, the affidavits are both the pleadings and the evidence. And so there has never been a pleaded reference in founding or supplementary to this. Maybe there's one in reply. I haven't bothered to look because that's not good enough with respect, as your ladyship knows. But it is very much an invention that has emerged for the first time in argument today. There's one paragraph which refers to it in the heads, and that, with respect, is the end of the point. Because it can never be that your ladyship can hold Mr. Guana liable for a provision on the basis of a provision which was never relied on, and which we certainly would have challenged had we known that it was to be relied on.
In fact, the Companies Act actually contains provision that support your argument.
Indeed.
In setting out circumstances under which a director who would otherwise be found liable for a decision that caused loss to a company is excused.
Yes.
From liability.
Yes. I'm indebted, your ladyship. I must confess that point hadn't occurred to me. Your ladyship's quite right. In other words, this would impose a standard far higher on an ordinary member of the operations committee than would be
prescribed officer. I mean, there are cases that
yes.
the members of the OPSCOM are prescribed officers in terms yes. of the Companies Act.
Absolutely right. Absolutely right. So, you know, my lady, your ladyship, of course, does not have to decide today whether a clause like 5.2.3 is valid, because it simply hasn't been raised. All your ladyship need to decide is that it hasn't been pleaded. And that is really the end of it. And my learned, I do, and my learned friend, Mr. Motepe, and I are genuinely good friends. So I do appreciate the difficult position he's found himself in, having to pick up a case he didn't plead. But with respect, this point was not pleaded, and it can't now be raised as a basis for repayment relief. My lady, that renders it somewhat unnecessary for me to take you through the detailed facts regarding Mr. Guana, because we've set them out, but they go really to questions of negligence and good faith. I'm very happy to address them to your ladyship if you like, but
Please
given
do.
that my learned friend, let me do that. Thank you. So if I could then turn to the heads of argument at paragraph 45 and following. And what we do in those paragraphs is we deal with what Ms. Guana's answering affidavit explains about the various meetings and events that took place. So we first deal with the group X, paragraph 47, and we deal with this in chronological order. There's the group EXCO meeting of 26 July 2016. And what is explained is that the question of the payments to the music legends served before the special meeting of the group EXCO. Can I just pause immediately? Your ladyship will recall that my learned friend tried to make something of the point that the operations committee has certain powers, but if needs be, it can escalate up to EXCO for guidance. That was the point.
Yes.
But of course, in this case, as I demonstrate, it had already been approved by group EXCO by the time that it got to OPSCO. So this went the other way around. It went EXCO and then to OPSCO. And of course, OPSCO cannot then go and overrule EXCO. That's the point we're going to make. So the group EXCO meeting, which consisted of the 3 group executive officers, 8 group executives. It was chaired by Mr. Aguma, the 10th respondent. It was attended by Mr. Motsoeneng, the first respondent, and it was attended by Ms. Rafela, the second respondent. So those 3 executives that my learned friend quite fairly, he repeatedly kept saying, even if you're not with us on the OPSCO, you must at least be with us for the 3. If you're not with us on the OPSCO, must be with us on the 3. I express no view on whether your ladyship should be with them on the 3, but I do say that they are in a different category because they were at the Group Exco meeting. And there your ladyship will see that the Group Exco meeting specifically discussed payment of 50,000 Rand to each of the music legends. That's paragraph 47.5. And that Ms. Tugwana did not attend the meeting due to other pre-existing commitments. So whoever else is liable, Ms. Tugwana can't be liable because she was, even on 5.2.3, because she was not at the meeting. So that's the first event. Thereafter, so 4 days after this Group Exco meeting, a public announcement is made. And the public announcement is made that there will be 50,000 Rand paid to each of the legends. And this is effectively admitted in reply. It's done on a live broadcast on SABC2. Mr. Motsoeneng and Mr. Aguma participate in the live broadcast. So does the Minister of Communications, the Deputy Chair of the SABC's board. And so it is clear that the SABC's board and the Minister were well informed of the decision to give monetary reward to the identified music legends. And all of this happens before the OPCO meeting. Now, my lady, let me just pause there for a moment. This is where the case is not identical to, but is somewhat similar to Gajima, because your ladyship drew to my attention in Gajima that Gajima had been misled by CETA's announcements. Well, with respect, you could make the same argument here, that in effect, the members of the OPSCO were misled by what had been a Group Exco meeting and an announcement to the public, that they thought this was all a fait accompli. But again, you don't necessarily need to go there for purposes of the prescription point, but I make the point because it is a helpful analogy. So we have the meeting on the 26th of July, the Group Exco meeting. Then we have the announcement on the 30th of July, not just to the musicians, but to the public. And then thereafter, a month after, more than a month after, we have the meeting of 5 September, for which my client is said to be liable. And that is the meeting which she attended. And what she explains is that she did not consider that she was authorizing the Legends project at all. This is all on oath, but I'm at paragraph 53 of the heads. And every time we have given you the reference to the answering affidavit and explained where it's not denied in reply. So you will see footnote 50 to paragraph 53 explains that the answering affidavit, page 231, paragraph 33 explains that she did not understand that she was authorizing the Legends project. The meeting was an impromptu meeting called at the last minute by Mr. Motsoeneng. No meeting packs were distributed, and there was no vote taken at the meeting. So there was never a vote taken at this meeting. Instead, the fact that the decision to pay 50,000 Rand to each of the legends was already a fait accompli by then is apparent from what Mr. Motsoeneng told the meeting. And if I can just read it, he said, "Are we done, colleagues? Okay, we're done with the stadium. This people will be paying our own legends. Kaiser, I know some people have been complaining about the SABC, some paying no, we don't have money to pay these artists. We will be paying this week. But there is a process that Tandeka and Nompumelelo and the Leslie team, Portia, they're working on this, but we will be paying before the end of this week." So I think the team is busy finalizing now everything, colleagues. There were also issues, the artists, there are so many. It's absolutely clear, my lady, that the fourth respondent had already received instructions to effect their payments, and Mr. Motsoeneng reported that these would be effected by the end of the week. That is absolutely clear. And again, we make the point that is what is said, footnote 53, that is what is said in answer, and it is not denied in reply. Then Ms. Tugwana says she did not understand she was being asked to approve or authorize the payment for that. That is denied, but it's a bald denial effectively, or not a meaningful denial. And she says this is, and we say that's unsurprising in light of what had already transpired by then. A Group Exco meeting, a public announcement on TV, involvement of the minister and the board, and so on. And we plead that Ms. Tugwana's understanding was that the decision had been taken, had been announced to the nation live on TV by the minister, the CEO, and the CEO in the presence of the deputy chairperson of the board, and that her understanding was and is that it was being tabled before the OPSCO because it was the responsibility of the OPSCO to implement the decision. So the OPSCO was just discussing the operationalization of the decision, of the pre-existing decision which had been taken by EXCO, and indeed that such operationalization, a terrible word, is indeed the core mandate of the Operations Committee and is confirmed by the vigorous debate among the members on the criteria for determining who is a legend. So what you see is there were long debates about who is a legend, who isn't a legend, and how do you pick them, but they're not debating the finance. Well, why are they not debating the finance? Because that's already been approved. So they're just debating how to implement it. And then we say that this is perfectly consistent with the terms of reference for the OPCO, which are quoted by the applicants in their heads. Now, these are the very terms which my learned friend relies on. This is the very passage he relies on, but it's against him because it says the OPCO must have due regard to the fact that it does not have independent decision-making powers. So the members of this committee knew they didn't have decision-making powers. And then it says the committee makes recommendations to EXCO except in circumstances where in situation where the EXCO authorizes the committee to take decisions and implement them. Thus, in undertaking its duties, the committee must have due regard to the subcommittee of EXCO unless specifically mandated by EXCO. Really, what that says is OPCO is not a decision-making structure. EXCO is. So EXCO has made a decision. It's announced in public. It's announced at the meeting, and now OPCO is blamed for the decision. With respect, it makes no sense. The very clause our learned friend relies on is fatal to his argument. And then, in any event, Ms. Tugwana's understanding was that Mr. Motsoeneng intended to raise funds from private funders to fund the project. Of course, we've heard that that's apparently wrong. Apparently, that was not the case. Well, with respect, it's about what she knew at the time. And that's the reason we've drawn your ladyship attention to all of those cases. Telematrix, the Black Sash case, I'll come back to it in a moment. But that's because it's all about what she understood at the time. So those are the three events so far. Then finally, on the 30th of September 2016, there's the approval of Mr. Aguma. So your ladyship will have the sequence. 26 July is EXCO, 30 July is the announcement to the public, 5 September is OPCO, and then 30 September, Mr. Aguma, who is the GCEO, he approves the business case. And that has been supported by Mr. Motsoeneng, or prepared by Mr. Motsoeneng and supported by Ms. Rafela, and there's no suggestion that Mr. Tugwana had anything to do with any of that. It was only after that business case had been approved by Mr. Aguma that the first batch of payments followed promptly on 13 October 2016. And so if any formal authorization was required, it was provided by Mr. Aguma's decision, not the OPCO decision. And so that's why we say, with respect, I make no submissions in respect of any other respondent. And in particular, I make no submissions as to whether Mr. Aguma, Mr. Motsoeneng, or Ms. Rafela are liable. My learned friend has already indicated that they stand in a different position from my client, and I agree with respect. I make no submissions on whether they are liable, but my client cannot be, for the reasons we set out in paragraph 59. She didn't attend the Group EXCO meeting on 26 July. She only attended the OPCO meeting on 5 September 2016, where she understood concerned the implementation of a decision already taken and announced to the world. Moreover, she understood that Mr. Motsoeneng intended to raise funds from private funders, and the SABC would not be out of pocket. And in any event, the formal authorization came not from the OPCO, but from the decision of Mr. Aguma on 30 September 2016 to approve the business case. So in those circumstances, we say at paragraph 60, it can't be said that her decision even caused the payments concerned, but it certainly cannot be said that she acted in a corrupt, fraudulent, reckless, or grossly negligent manner. Where do I get those terms from, my lady? I get them from the authorities cited in the heads of argument at paragraphs 28 through to 38. If I could take your ladyship there to finalize the submissions. If I could ask your ladyship to go to paragraph 28.
Yes, I'm there.
Thank you, my lady. There we make the point that the applicants provide no explanation as to the legal basis for the repayment relief. They don't explain under what circumstances it's permissible and appropriate to hold state officials personally liable. They don't explain to what extent a breach of a public law duty can produce private law liability on the part of officials. And they don't explain why the conduct of Ms. Tugwana meets any test. Now, I'm going to come back in my last point to say, well, they now get to all of this, but they get to it by means of 5.2.3, which they never pleaded. But let me just leave that aside for a moment. So all they say previously is just and equitable relief. They give your ladyship no authority for the notion that making officials pay back is just an equitable relief. And we then take you to the wealth of authority cautioning against holding public officials personally liable too freely. Because, my lady, it sounds, forgive the term, politically correct to say officials who are involved in wrongdoing must pay. That is something we all subscribe to. It sounds good. It sounds like a good principle. But with respect, the question is under what circumstances? Because what the courts have said is if you are going to hold officials liable every time they're involved in something that goes wrong, you are going to have no officials left. Or you're going to have officials left and everyone will be too terrified to take a decision. And you must set a higher bar. And that is what is made clear by cases like Telematrix and Steenkamp and Black Sash. So Telematrix in paragraph 33, the SCA said, that's about the Advertising Standards Authority, but what it said, Justice Haram said, in different situations, courts have found that public policy considerations require that adjudicators of dispute are immune to damages claims in respect of their incorrect and negligent decisions. The overriding consideration has always been that by the very nature of adjudication process, rights will be affected and the process will bog down unless decisions can be made without fear of damaging claims. Well, this damages claims are exactly the same here. If every time there is a decision to pay money, there is a fear that you're going to be sued for merely getting it wrong, you're going to bog down the government. Steenkamp SCA said the same, quoting the Privy Council in Rowling versus Takaro. A comparable danger may exist in cases such as the present, because once it has become known that liability and negligence may be imposed on the ground that the minister has misconstrued a statute and acted ultra vires, the cautious civil servant may go to extreme lengths in ensuring that legal advice or the opinion of the court is obtained before decisions are taken, thereby leading to unnecessary delay in a considerable number of cases. My lady, it's a difficult thing to say, but decisions have to be taken. They must be taken lawfully if possible, but decisions have to be taken. And you can't, with respect, have a reasoning which would prevent public officials from doing so. And that caution, my lady, has been embraced by the Constitutional Court in its judgments about costs orders. Because in Black Sash 2, which we cited paragraph 37.1, the Constitutional Court made clear that a costs order against a public official in their personal capacity, and that's what we're talking about here, personal liability, should only be made if a public official has been guilty of bad faith or gross negligence in connection with the conduct of litigation or the conduct of the official's duties. And the rationale underlying this rule is that courts should be slow to grant costs orders against public officials because these orders may dissuade them from carrying out their statutory functions, and this would have an impact on the public interest, a negative impact. So, my lady, the question to be asked with respect is, have they proved on the facts a case that my client was guilty of bad faith or gross negligence? My lady, not remotely. Not when you consider the summarized facts that we've put up at paragraph 59, which is she didn't attend the Group Exco meeting. She merely attended the OPCO meeting, which she understood, common cause, not denied, which she understood concerned the implementation of the decision, or baldly denied, let me be fair, baldly denied, but no denial of the underlying facts. And she understood that Mr. Motsoeneng intended to raise funds from private funders, and she did, and the authorization from the payments came from Mr. Aguma, not from her. In those circumstances, my lady, even if your ladyship were to find against us on prescription, there is no claim against my client because her liability has not been established. And that is why, with respect, my learned friend tries to pull a rabbit out of the hat by referring to 5.2.3. 5.2.3, my lady, would drive a truck through the Companies Act provisions you speak of. It would drive a truck through the Black Sash case, through the Steenkamp case, and through the Telematrix case, because it would say, my client is liable, even if she acted in good faith, even if her decision was misled by Mr. Motsoeneng, even if her decision was the right decision at the time, essential at the time, she is still liable for the losses suffered. My lady, I have never come across such a principle, and it would be at odds with the principle of director's liability. I will give your ladyship the reference to Kutsia when I give your ladyship the references. And that's why my learned friend tries to rely on 5.2.3. If he had pleaded it initially, we would have had a very interesting case, but he hasn't pleaded it, and having not pleaded it, it can never be a basis for my client's liability. My lady, subject to the additional references I must give your ladyship and any questions, those are my submissions.
Thank you, Mr. Bucklander. I think this is a good time to take the lunch adjournment.
Thank you, Malay.
It's now 25. So you will come back after lunch, Mr. Bucklander. If you could to give me the references for the authorities that you relied on, where you didn't give me references.
Certainly, Malay.
Is 30 minutes sufficient for lunch?
Certainly, my lady.
Sufficient, my lady.
So we will return at...
Yes, we agree 30 minutes, my lady.
Thank you. We'll return at 2 p.m. We adjourn.
20.
Please repeat the Ingledew citation for me.
2003,
Yes.
volume 4,
Yes.
SA
SA
584, CC at paragraph 20.
Thank you.
And then the case by loose analogy on when directors should be held liable is S versus Coetzee,
Yes.
1997, 3 SA 527. A decision of the Constitutional Court at paragraphs 57 to 59 and 101.
Yes.
Thank you, my lady.
Thank you. Thank you, Mr. Buckland. Not sure who's coming next. Okay, you may come in any order then.
And then perhaps they must come in the order of, oh, there's someone at least.
Milady, in the instance, I suspect that I am the most junior out of all the respondents. To the extent that we are now going in any order, might I please prepare my notes, 5 minutes for that, if your ladyship may grant the indulgence.
That's fine.
As it pleases the court, milady.
May I please, my lady? Yes, my lady, I feel compelled to not keep my lady on the screen waiting and the parties not saying anything. My lady would recall that I am for the second respondent. However, my lady, I actually am the one who believes that is the most relatively junior of all counsel, and I think, as my lady had actually proposed earlier, it would be I would do disservice to myself and to my client if I were not to benefit from submissions from seniors, whom, in any event, my lady, makes out the same case as we do. And for that reason, as I say, my lady, I feel compelled that my lady is not on the screen alone and waiting for parties to appear, and nobody appears. So I am on the line, but I will wait for seniors, my lady. As the court pleases.
Yeah, I'm not sure what the order of seniority is. That's why I rely on counsel to just come up. But I have since changed the directive, given that protocol does not seem to be working well. So any counsel may address me at this point. Anyone who's ready. Should I adjourn the court?
My lady, if you may please the court, like I said, I elected to bet last, but if there are no other counsel who are prepared to argue, we can bring our arguments to the fold at this juncture.
Thank you.
Given we're elected to bet last because of the counter application, which is also similar to a collateral challenge that we have before this court.
It really doesn't matter. So you may argue, you may proceed to argue.
Okay, just give me five No, 2 minutes actually, just so that I can just get my heads on this on the screen, as it pleases the court.
Okay, I'm going to adjourn the court for about 2 minutes. Ms. Nyati, are you ready?
Yes, my lady.
Yes, thank you.
Just for some housekeeping, my lady. I do apologize. Our heads of argument, both the first set and the second set, uses the paginated numbers of those that were uploaded rather than the case lines pagination system. At the time of the heads of argument being drafted, I wasn't aware that there was already a pagination system on case lines. So I do beg your ladyship's indulgence on that, and I do apologize for that. Thank you, my lady. I would also like to state that we align ourselves with the submissions that were made by the seventh respondent in reference to new submissions or the new argument or the new case that has been advanced by the applicants. And this new case has been advanced in their replying affidavit as well as their heads of argument. And my lady, we do refer to two cases in this respect where all of the respondents have now had no opportunity to answer to these allegations in the appropriate manner. Of course, the reason why a case needs to be set out in the founding papers is to avoid where there is an answer, a reply, a further answer to that. And the applicants have placed us in that situation. They have raised new allegations and in fact, it appears new facts where our clients have just not been able to respond. And that appears at paragraph 45 of our first set of heads of argument. And we refer to two cases as well. That is the case of Bayat versus Hansa. The citation is 1955, volume 3, SA 547 at 553, paragraph C, my lady. And it states there specifically that an applicant must, for the relief that they seek, make out his case and produce all his evidence in the notice of motion, whether he's moving ex parte or on notice to the respondent. The applicant is not permitted to supplement in his replying affidavits, which serve the purpose of replying to the averments made in answering affidavit, still less to make a new case in his replying affidavits. Similarly, my lady, there is a second case that is Shakot Investments versus Town Council of the Borough. And the case citation for that is 1976, volume 2, SA 70 at 704, paragraph G. A party seeking relief ought in his founding affidavit to disclose such facts, if true, justify the relief sought, which would at the time sufficiently inform the other party of the case he was required to meet. And your ladyship has also referred to the Companies Act, and we align ourselves with that as well. And just to give an overview of what I will reply to or give an answer to during argument, I will address the non-joinder of parties. We have raised that in our heads of argument, milady. And secondly, I will briefly refer to unreasonable delay. All of the parties have referred to the extensive period of time that both the SIU and the SABC have taken to bring this matter to the court. Thirdly, I will refer to the grounds of review, with particular emphasis on compliance with the policies of the SABC. And after that, I will conclude. On the first point of non-joinder, milady, there have been multiple references made to the former board of the SABC in the applicant's founding papers. The applicants also make a reference to the board's lack of knowledge of the Music Legends project. This is notwithstanding the public announcement. Milady, at no point in time is there a confirmatory affidavit or even a supporting affidavit of any one of these board members. And my client, Mr. Motsoeneng, does state in his answering affidavit that the board was informed. This appears at paragraph 9 of his answering affidavit. Let me just get the pagination number. Paginated number 75, and I'll give your ladyship the reference as well in the case lines management pagination system. At the moment, it is the normal number, page 75.
You don't need to do that, Ms. Nyati. It's okay for you to rely on the document pagination.
Thank you, milady. He does state that the board was informed and endorsed the value of the once-off recognition project. In reply, the SIU merely states that they deny this allegation. They do not give a confirmatory affidavit once again or a supporting affidavit as to the reason why they state that they deny Mr. Motsoeneng's allegation that the board was aware. And even from the record that has been presented to both us and to your ladyship, there is no audited statement. There is no minute of the board of the SABC which has been presented. We are left with minutes, yes, and I submit that those minutes show that multiple conversations and discussions were held as to the inherent risks which came with having a project of this nature. And the minutes show that. But what the record does not display is that the board had been referred to this. Nothing of that nature is in the record, milady, and nothing of that nature is in the exchange of affidavits as well. What we're going off of at this point in time is mere hearsay that has been presented by the SIU. In respect of the undue delay, milady, we have made submissions on this in our heads of argument, and we also refer to a report which was provided by the SABC to the SIU on 3 August 2017. And I refer your ladyship to paragraph 19 of our first set of heads of argument. The report is titled Final Report, Legends and SABC Heritage Concert. And milady, the conclusion in that report, it's dated August 2017, was that we investigated payments pertaining to local music legends. We found evidence to substantiate that the payments made to the local music legends and the sponsorship were irregular, as this was done in contravention of the SABC policies. And thirdly, that the SABC should recover an amount of 2 million from Mr. Motsoeneng for the payments made. Milady, both parties for every single allegation that they now raise in this application had already been raised, highlighted, investigated on the 3rd of August 2017. And every one of those allegations in the report, Milady, are those both in the SIU statement on the record that has been provided, as well as the founding affidavit. There's nothing new which has been produced. And Milady, the applicants use a very interesting word. They say that their explanation for delay is porous in nature. Milady, I submit that their explanation for delay does not justify the period within which they came to this court. And the reason why I state this, Milady, is the SIU refers only to 3 dates as grounds or reasons why they delayed to such an extent on bringing this application to the court. The first date is that of March 2017, where they refer to the interim board being appointed. The second is that of 1 September 2017, when the SIU began its investigation. And after that, it states that it was in 2 phases of investigation, which spanned a period of 2.5 years. We do not know what happened during that 2.5 years. And the third date which is given is where they state that they completed the investigation on 6 July 2020. And Milady, the applicant also referred to SIU versus ESS and contended that the facts in that case are not similar to our own. Milady, the principles that are set out apply directly to this. And in the SIU versus ESS, at paragraph 45, the court states that the explanation they gave did not account for the full period. It does not withstand scrutiny. The applicants did not act promptly in bringing the review application. On the contrary, they differed and focused instead unreasonably on cancellation of the agreement and other court and arbitration processes, which the SIU admitted it was not party to until it intervened at a later stage. And Milady, I refer to this particularly because the SIU makes reference to the word matters. I would just like to get the reference for that. At paragraph 48 of the applicant's founding affidavit, the paginated number is 25. The SIU states in the 3rd line that this period is justified. This is after the proclamation of 2017, allowing them to commence investigations. It says that this period is justified having regard to the complexity of the matters. The word that they use is plural, Milady. And this, in turn, is of concern because the proclamation itself does not refer to any other matters. It refers to whatever funds that may have been mismanaged during the period. And this is at paginated number 42. This is SIU 2. It refers to any procurement of contracting services which were had been mismanaged or had the possibility of being mismanaged or unauthorized, irregular, or fruitless. And also in SIU 1 at page 40, that they investigate the maladministration or any connection with the affairs of the SABC which were improper or unlawful, only for the period from that period and the date of promulgation on in September 2017, Milady. Whatever other matters that the SIU may have had to concentrate on does not link to the management of the SABC during the period of time in which they were mandated to investigate. Instead, they were focused on any other matters which they refer to in plural. And their explanation also consists of unaccounted periods, and this, my lady, I submit, is unreasonable delay. To the extent that your ladyship does overlook that delay and find that the decisions that were made were unlawful, we do align ourselves with the submissions that were made by the 7th respondent with regards to the monetary claims, and we do submit that there are no grounds for seeking the monetary claim against the respondents. And on one more item, milady, and this was a point that was raised by the applicant today. The applicant stated that the business case that was referred to by Mr. Motsoeneng and or the operations committee and any other member of EXCO was only made to increase the number of persons in the number of music legends that were to be incentivized or compensated. My lady, I refer you particularly to the SIU's founding affidavit. This is at paginated number 19 and paragraph 31.2, where they themselves set out the purpose of the business case. They state that the purpose of the business case, and I'm quoting from the affidavit, was to motivate for the payment of the music legends. It was noted that the music legends were to be paid an incentive for supporting the SABC and also to compensate the music legends who did not receive needle time royalties. And 2 lines after that, it states that it was further noted that the payments were to be made and processed from cost center 1721. My lady, any other submission that has been made by the counsel for the applicant today in court, which is not an affidavit, is evidence from the bar, and I submit that cannot be done, and your lady cannot take those submissions for what they have been made out to be. On the merits, my lady, and this is with reference to the grounds of review. If I can just have 2 minutes, please. Lady, the applicants raise or have rather brought this application on several grounds of review. That is rationality, that is to the arbitrariness of the impugned decisions, legality of those decisions. Where rationality is concerned, firstly, I would like to refer your ladyship to Zuma versus Democratic Alliance and others. And this would be at paragraph 32. And imperative in that paragraph is where it states that if there is a failure, or rather let me start it at the line prior to that, rationality review covers the process by which the decision is made. So both the process by which the decision is made and the decision itself must be rational. If a failure to take into account relative material is inconsistent with the purpose for which the power was conferred, there can be no rational relationship between the means employed and the purpose. My lady, we have submitted that the decision that was made was rational in light of the constitutional mandate of the SABC, as well as the mandate of that in the Broadcasting Act. And once again, the applicant refers to sections 2A and 2R of the Broadcasting Act. With respect, my lady, it states that the broadcaster must implement policies, and the broadcaster, the SABC, has implemented policies. And a part of the policy-making process was the provision to allow that expenditures be spent where it has not been in budget, and that is where clause E13 comes into place. A policy is in place. It makes concession or the allowance for a project of this nature to be made. It's in the same case of Democratic Alliance, that the Zuma versus Democratic Alliance, that the rationality standard is by its very nature the lowest possible threshold for the validity of an executive decision. It involves restraint on the part of the court. And that is because where there is a state, an organ of state of this nature, such as the SABC, there are certain powers and decisions that are exercised by the persons in the executive committees as well as the board itself. They have particular experience with regards to those decisions that are made and the application of any decisions that are made within that body. The applicants, in their heads of argument, refer to the arbitrary and irrational manner in which Mr. Motsoeneng came to his decision on 26 July 2016. My lady, we submit that no decision was made on this date. Instead, it was a proposal which was made by Mr. Motsoeneng. And in paragraphs 10 to 11 of our first set of argument, we have referred to the events of 26 July 2014. The applicants, with reference now to the 5 September decision, state that the respondents had no set objective criteria to determine who qualified as a music legend. They also argue that there ought to have been a framework or guideline in place that outlined how the music legends were to be considered and on what basis. The lady, in the minutes of 5 September 2016, this appears from the record. Yeah, we'll just get the pagination numbers. The paginated number on the record is page 765 at MD 33. And in those minutes, my lady, it states that a communication plan for the once-off payment was discussed, which highlighted that the SABC would communicate with all the relevant stakeholders that payment would be effected after confirming beneficiary details, which included those legally entitled to receive royalties of deceased estates, as well as the selection criteria which had been applied. There was then a resolution that was made that the Music Legends project was approved and that the initial list must be reviewed to ensure completeness and all beneficiary details. There is also a resolution in the same minutes of 5 September that all the musicians who have been unintentionally omitted or approached by the SABC must be managed on a case-by-case basis. And this is to eliminate possible duplicate payments. This is in the minute itself, my lady. There is also a document that is titled Legal Basis for Music Legends Payment. And this, my lady, appears at page 1740 of the applicant's record, that is MD 56. In the proposed legends payment criteria, my lady, at paragraph 6, there is the heading Proposed Music Legends Payment Criteria. At 6.1, it states recipients. A recipient of an ex gratia amount will be a performer from historically disadvantaged background, and there are 4 other stipulations there. At paragraph 6.2, there's also a time frame within which that performer must have had their career or must have been in the music industry. At paragraph 6.3, there is a heading titled Commercial Success. It states that the recipient of any one of those payments must have at least 1 album and whatever genre, and it also stipulates the platinum status and the sound recordings. At paragraph 6.4, it refers to the leadership and influence that veteran musician or music legend must have had, and at 6.5, it refers to the awarding of those payments to disadvantaged groups. My lady, these are all criterion. In fact, this was proposed criterion before any payment was made. There's a further report on the allegations matter, and this appears at the applicant's record on pages 1744 to 1745, my lady. The report states that it was noted that the list used at the start of the project did not clearly define a legend. Various meetings were held with legends bodies and the SABC to try and reach a common ground and put in place clear criteria with regard to the legends. It was put on hold as a result. I suspect that this was the beginning of 2017, my lady. There is no date on the report. Once again, they refer to the criterion which I have previously highlighted and stated to your ladyship. My lady, it cannot be said that there was no criteria or framework or guideline which the decision was made on. And this is on the basis of the ground of review that has been raised by the applicant, which we have been able to answer to in our answering affidavit and similarly so in our heads of argument. And with regards to the response that was given to multi-choice, in as much as the applicant has referred to particular paragraphs wherein they state that they weren't aware of the project or a project of this nature, multi-choice does state at pagination number 895 in the applicant's record, and I'm quoting directly from it, "We have taken the necessary steps to identify and speak to employees of MultiChoice." And in the 4th line, they state that we wish to point out that our content team is involved with many negotiations on an ongoing basis, and that it may be difficult for them to recall exact details of all members, or rather of all matters, and going back to many years. And the many years, my lady, I submit also speaks to the delay once again. It has been years since 2017, August 2017, at the very least, where the full investigation forensic report was submitted to the SABC, and that is the forensic report which the SIU now uses. And MultiChoice then states that information provided herein is accordingly to the best of our team's recollection. My lady, the SIU does not provide the financial or audited statements of the SABC to state that these payments came directly from the SABC itself, and any reference to cost center is the office within which those payments were made. It doesn't state where the funds came in from. They do not even attempt to provide this information to us. To the extent that, again, well, I think I've covered this basis with regards to the Broadcasting Act. The SABC's purpose and mandate is unambiguous. It has been set out in the Broadcasting Act. The policies which are within the SABC, as well as any other delegations or policies such as E13, which make provision for projects of this nature. And, milady, to the extent that the applicants argue that the decisions were unreasonable or arbitrary, and for that they state that the basis for that is there was no source of funding, that Mr. Motsoeneng misrepresented the source of funding, and that the operations committee, that's the term that they use, failed to ensure that the Music Legends project was in line with the SABC's goals. My lady, I have covered this. The E13 allows for this. And again, we do not know what the board even had before them. We don't have any minutes of the board. We don't have any of affidavits confirming what occurred during that period of time. And with regards to what the court would look at when a decision or the reasonableness of a decision is put into question, I refer your ladyship to the case of Beto Star. However, I must highlight that this was in reference to Paja. However, I think as we all understand that certain principles do apply also to legality reviews in respect of the manner in which those grounds are viewed by the court. And at paragraph 45 of Beto Star, the court states that when looking at whether a decision is reasonable, factors relevant to determining this will include the nature of decision, the identity and expertise of the decision maker, the range of factors relevant to the decision, the reasons given for the decision, the nature of the competing interests, and the impact of the decision on the lives and well-being of those involved. My lady, the respondents were all appointed as members of either the operations committee or the executive committee. They have their expertise in broadcasting as a career, and they have made extensive deliberations. This is evidenced by the applicant's record as to the financial implications, the business risk involved, the payment of those artists, which initially had been to 10 million and was then reduced to 2 million, rather the payout was 2 million. The compliance requirements, which would have needed to be met in terms of the delegation of authority, is quite clearly shown. And my lady, another thing that we must highlight is there was no malafides. In fact, the applicants do not even make a submission of this nature. There were no ulterior motives. The applicants do not claim that there were ulterior motives. All of the respondents, or rather those respondents who made the decision to approve the Music Legends project, applied their minds. They applied their minds to the criterion that was applied, and they applied their minds to the persons who would receive that payment. And that is also evidenced by the multiple applications that are made in the record itself. This appears in the applicant's record, where there are banking details, letters from the bank as well, confirming that these details are in place, IDs, and there's a further process of application where those music legends or those who sought to claim from the project had to submit. And lastly, my lady, the Legends project was one which sought to recognize music artists who were deemed music legends, and their music was used over the years by the SABC. And the importance of this is it relates directly to needle time rights. During that period of time, those musicians would not have been able or would not have gotten anything with regards to the royalties, which they would have ordinarily deserved, more so prior to 1996. And the SABC made the use of those sound recordings. The SABC made use of the intellectual property of those music legends. And that is why there was a proposal of this nature. And for the executive committee, to the extent that it was involved in the approval of that project, there was no other foul play, there was no corrupt practice, and there was no interception of funds. It is unclear to me why a payment is sought in the respondent's personal capacity, and a case is not made out on that basis, my lady. And those are the submissions that I have to make, unless your ladyship has any other questions for me.
I'm very concerned as regards your client. The allegation. I'm saying the SIU case against your client, that There was no funding from MultiChoice on the facts, and for that reason, he misled the members of OPSCO. If I make that factual finding that in fact there was no such funding, would you agree that that is the basis on which I would find that he made the decision, the impugned decision, in bad faith?
I do not agree with you, my lady. And I have received instruction, this was a little bit earlier from my client, that to the extent necessary and where your ladyship would like to be addressed on where this funding came from, my client is willing to give viva voce evidence of that, and is also requesting that the audited financial statements of the SABC be made available to your ladyship so you can see where that funding has come from. Once again, they have referred to a cost center 1712, if I'm not mistaken, where payments were made. So it's where monies were received, but the payment was made outside of that. It does not show where the payment of those monies came from, my lady. Once again, my client is willing to give viva voce evidence of that.
So are you saying there's a dispute of fact that cannot be
I am saying that, my lady.
Issue, and it should be referred to oral evidence?
I am stating that.
Yes, but I've asked you a very different question, because the test applicable to a factual finding in the event that I am of the view that the issue is resolvable of the papers is that of Plascon Evans. And if I find that your client has not disputed the allegation that no money came from MultiChoice, do you agree that then I should find that he made the impugned decision in bad faith?
My lady, you're asking that to the extent that my client has not disputed that MultiChoice
has not seriously disputed.
Has not seriously. He has stated in his answering affidavit that he was in discussions with MultiChoice and that funding came from MultiChoice. My lady, I submit that is a dispute.
Yes, I don't recall him giving any particularity regarding those negotiations.
My lady, I will just briefly go through this affidavit and I will refer you to those paragraphs in his founding affidavit where he does state that. Sorry, I beg your pardon, in his answering affidavit. Pardon?
Yes, no, I was correcting you. It said in his founding, it's his answering.
Answering affidavit, yes, my lady. And his answering affidavit begins at paginated number 72.
Please refer me to the relevant paragraph.
Yes, my lady. At paragraph 25.2, at paginated number 80, Mr. Motsoeneng states that the funds used to implement this project were specifically raised from private sources, more particularly MultiChoice. He states that I raised 5 million rand towards that project and 15 million for coverage of the national elections from private sources. The entire amount was accounted for and reflected in the audited financial statements of the SABC. And my lady, with regards to this, I'd just like to highlight that this affidavit was deposed to in 2021. This is about 4 years after the decisions were made, or the impugned decisions were made in 2016, or at least 5 years. He would not have had access to those audited statements, but the SABC and the SIU does.
Ms. Nyati, the question I put to you, you have not addressed, and that is he's not provided any particularity regarding who he negotiated with, when were the negotiations, when was the decision made, when was the payment made. He's simply relying on the fact that this information should be on the financial statement. But of course, the SIU and the SABC have replied to this with reference to affidavits deposed to by officials in finance who say there was no such funding. So I'm saying on the versions of the two parties, if I'm not satisfied that he has seriously disputed the allegation that there was no funding from MultiChoice, why should I not find that? Because he misled, because there was no such funding. He misled Opsto, and therefore he acted in bad faith.
My lady, I submit that one cannot really say that he misled anyone. And the reason why I say that is with the affidavits that have been provided, many of these persons state that they weren't aware of the project, although the minutes show that the project was discussed. And once again, my lady, no audited statements, which I submit is imperative to the findings that you made, was submitted by either of the applicants.
Yeah, but aren't you asking the SIU here to prove a negative? Because they're saying there's no such funding.
My lady, based off of hearsay evidence.
What do you mean it's based on hearsay evidence?
I say that because there are no confirmatory affidavits from the board members of the SABC at that time.
So should I ignore the confirmatory affidavits from finance?
I do not submit that you ignore those affidavits, my lady, but to the extent that there is no confirmatory or supporting affidavit, I do submit that it is hearsay evidence.
Okay. Anything further?
That is all, my lady.
Thank you.
Afternoon, my lady.
Thank you, Mr. Hilita.
Your Lordship, earlier I had elected to bet, and then unfortunately I was overrun by the events, and I now wanted to address you with your leave, my lady.
Mr. Hilita, are you happy to come after him?
I've got no issues with that, my lady.
Yes.
Yeah. Thank you, Mr. Hilita, for the indulgence as well. Thank you, my lady, for the indulgence.
No, pleasure. Pleasure, my brother.
My lady, I'm not going to regurgitate a number of issues that have been argued before you by my predecessors and for which we are indebted for their arguments. They raise quite resonant arguments why the SABC and SIU is employed an incompetent legal strategy to bring these respondents before this honorable tribunal. And I say so with the greatest of respect that the legal team for the SABC and SIU have employed a legal strategy which is bad. And we have raised these issues consonantly so in our heads of arguments. And those issues, I will address you shortly on those issues, why we say the reasons proffered by the SABC in bringing this review application was firstly bad at law, and secondly, it is an employment of an incompetent legal strategy, and thirdly, it goes against the grains of the Constitution, in particularly Section 165, subsection 4 of the Constitution. SABC and SIU are organs of state. They are there to promote and build and assist with the defense of the Constitution. They are not there to use the Constitution in an abrasive and an unlawful manner to further their own ends when they were dilatory in bringing this said application, or when they realized that they were late in bringing forth litigation pertaining to recovering the 2.5 million to the legends matter. We'll come to that issue in a few breaths as we argue this matter before you, and why this application to be dismissed, and why also the 8th and 9th respondents have raised the counter application, which is they've gone further than what is normally courts refer to as the collateral challenge, which is in terms of the Truter versus the Genera 1990 volume 1 SA 2R6. It's a Transvaal decision, and also Minister of Transport and or versus Prodiba, which I'll refer to as the Prodiba decision. 2015 Zaska, page 38, is a Supreme Court of Appeal decision, and also the case of, I just want to quickly refer to the case of, I think it's Kobela Consulting and others. I'll give you the observation for that matter shortly, my lady, in arguments. My lady, we are emboldened in this argument that this matter should not even have seen the light of this tribunal at all. While we're emboldened in that matter, as I've addressed you on, my lady, that we say that the SABC and SIU are not ordinary litigants. They are organs of the state. They're there to protect and assist the court in protecting the Constitution. They've not done so. My lady, if you look from the flurry of arguments raised by the applicant themselves in this matter, they raise a flurry of arguments to say that there's no prescription. They say that they have the delay is not unreasonable, and they've not explained at all why the court need to overlook the delay. They've not even tried to bring the court to their confidence by trying at least to enlighten the court and enlist in a enumerative fashion the factors that the Constitutional Court has displayed in Tasima 1, that there are a certain number of factors that they need to put the court into their confidence in order to overlook the delay. None of that has been happening. What they've just sought to do is that they've sought to ring-fence their argument by the usual cry of the day. Any officials that have done badly, who were or are officials of state organs, they must face the full wrath of the law. We say yes. Any official that has done something wrong must face the full wrath of the law. But is it that in this case? No. The answer is nugatory. And I say it is nugatory, my lady, because all that the SABC, that is the pair, what they've just simply done is to try and convince this court with empty air. They've not proffered any reasonable argument whatsoever that is consonant with the review applications in Gijima. They've tried to use Gijima as an upshot of the argument. And unfortunately, actually, Gijima fails. They fail the straddles of Gijima in all respects. My lady, if you look at this matter, the issues are simple and straightforward as follows. The decision was made on the 3rd of August 2017. By at least September, the pair ought to have known, notwithstanding the fact that they sought to set aside the irregular decisions, they could have, by that time, they knew who the legends were. So if they thought that the money was unlawfully paid out to the legends, they could have come out after the legends. They could have sued them as far back as 2017. They had ample time. But what did they do? They folded their arms and waited for this lengthy delay to institute these proceedings before the tribunal, because they hear that the tribunal is after any delinquent official. Yes, the tribunal must go after any delinquent official, but that is not so in this case. There are no delinquent officials.
The tribunal is not pursuing anybody, Mr. Kufa.
Well, it might be. The
tribunal is an adjudicative body. It's not pursuing anybody.
No, true, my lady. But the actual that is consonant with the tribe that people identify the tribunal with. It might be irregularly so that they associate the tribunal as if going after delinquent official, but it is still a good job to go after delinquent officials as part of the fact-finding exercise of the tribunal. So what I'm saying, I'm not saying that the tribunal is going after delinquent officials, but if there are any delinquent officials, obviously the tribunal is implored to go after those delinquent officials. But in this matter, that's not exactly what has happened. Here, what has happened
Я сейчас видео тебя пошлю.